not complied with, and therefore its proceedings have not started. And then to simultaneously say, but you've got the wrong.
Not simultaneously, later on.
Later on, that's what but the point, Justice Nuku, is that at the same time now the argument before this court is to say, but you've got the wrong committee. And we submit simply on that basis, the point is not a good one.
But if it's a matter of law that's so, then it must be open to the...
Of course, if as a matter of law...
It may be that they were laboring under a wrong impression that the proceedings that were underway could be interpreted as removal proceedings, and now they went back and they looked closely and it dawned on them that, well, this might not necessarily be, and it might well be a good point.
Yeah.
So isn't it better that for you to just address us on whether, even on their interpretation, the proceedings that are underway are removal proceedings, rather than to want to deal with their alternative arguments?
Yes. Justice Nuka, I'm going to address you on the merits of the argument, but I submit with respect that the points I make in relation to pleadings are not insignificant. They frame the case. The Constitutional Court has told us on repeated occasions that even where there are constitutional issues invoked in a matter, the principles in relation to pleadings remain. And in accordance with those authorities, the submission is that it's a bad case on the pleaded basis. Bad because the case isn't clearly pleaded out, and bad because it's inconsistent with the case pleaded in Part A of it.
Does it mean that if it's not properly pleaded, then it can't be raised in argument?
I'm sorry, just...
Does it really mean that if it hasn't been properly pleaded, as you say, although if there is an indication that this issue will be argued,
yes.
Are you saying that it cannot be raised here?
Yes, let me be clear on that, Justice Lekaleni. Of course, I don't take issue with a new point that's raised in argument, and according to SCA and Concord Authority, if it properly appears from the evidence in the matter and subject to the important caveat that there's no prejudice occasioned by that. The submission here is if it had been properly pleaded, it would have been properly dealt with as to the role of the 1943A committee, why there isn't a notion of two separate committees as contended for, and those are the kinds of issues that this court doesn't have the benefit of evidence on before it. But despite all of those arguments, Justices, we submit that in any event, when one looks at the rules, if I can ask the court to go to Bundle A, file, I've got it as file 2, and it appears in volume 5 at page 401. 401. And the role of this committee, Justices, is clear from these provisions of the rules. And if I can draw your attention to 129AA firstly, which says there's a committee to consider the motions initiated in terms of Section 194 and referred to it. If the court will then scroll down to 129AD, which deals with the functions and powers of the committee, and it says the committee must, when the Assembly has approved the recommendations of the independent panel in terms of 129Z, proceed to conduct an inquiry and establish the veracity of the charges and report to the Assembly thereon. And then it goes on with certain issues of process, and at 129AE, it has the heading decisions, and it says a question before the committee is decided when the quorum in terms of Rule 1622 is present and there's agreement among the majority of members present, provided that the committee reports all views, including minority views expressed in the committee, must be included in its report. And then 129AF, the report of the committee must contain the findings and recommendations, including reasons for such findings and recommendations. And so I must be clear here, members of the court, the submission is certainly not one to say, well, you can't use you must use the rules in order to interpret the constitutional provision. It's not that, but the submission is rather that the rules, which aren't the subject of attack at all in these proceedings, those rules contemplate that the committee, the 194 committee, as it is, carries out all of those functions as I've referred the court to. And so we submit that the argument that there ought to be a separate body and all of that just simply doesn't find favour within this framework at all.
The argument, if I understood correctly, was whether this Section 194 committee is in fact a removal.
Yes.
So that's not its function. Its function is merely to determine the veracity or otherwise of the charges.
And
so a distinction was made between that that function of the committee and another committee that doesn't appear to have been contemplated
Yes.
by part of the
Yes.
rules, namely the removal committee.
yes,
Are you saying that the 194 committee is in fact the removal committee contemplated in?
that's exactly the submission. That is exactly the submission, Justice Francis. And we submit that it's clear. There's absent an attack to the rules. When one has regard to those rules, it's clear, it can't be clearer, that its purpose is to give effect to 194 in its entirety. And so for those reasons, we submit that the new challenge is entirely without merit. And for those reasons, it must fail. There's perhaps a further point. The bench engaged with my learned friend yesterday as to what would then be the committee, how would its role and functions differ from the National Assembly. And the court didn't get answers to any of those questions. And that, in our submission, underscores the difficulty with the argument. And again, it brings me back to the pleading point, because had it been dealt with properly, these issues could have been dealt with on the affidavits.
Perhaps you could just go to 194.3.
Yes.
A.
Yes.
That makes reference to a committee of the National Assembly for the removal of that person. So you say there's no real magic to the phrase removal of a person. It must be seen within the overall context of 194.
Absolutely so.
So there's no distinction between the committee mentioned in 194.1b
Yes.
and 194.3a.
Exactly. Exactly. That is the submission. And the case may well have been a different one if the challenge had been brought to Justice Francis in terms of saying, this is what the Constitution provides for. The rules are deficient because the rules don't provide for these two separate committees, and it has in effect conflated the committees. It has done so impermissibly and in contravention of Section 194. That would have been a very different challenge. But that's not the challenge before this court, and the rules as they stand are what this court has to have regard to. So for all of those reasons, Justices, we say that the new challenge simply can't succeed. If I could then move on to the old challenge, and here I'm going to ask the court to just have before you the case that was made out in the founding affidavit. It's at page 36, as I say. So the first prerequisite that the applicant contends for the start of proceedings is that there must be a proper promulgation of amended rules. Now, the court heard my learned friend Mr. Breitenbach's submissions on that point, and we align ourselves entirely with that. The point is a simple one. The order that the Constitutional Court gave didn't provide for a directive for rules to be amended. The order itself provided for what the rule must actually state. So there's no question of a need for amended rules to be promulgated, and for that reason the argument is a bad one in law. Then our learned friends say at 91.3, the appointment of evidence leaders was a prerequisite. They accept in parenthesis there that this occurred on the 29th of March 2022. As the court knows, this application was brought, I think, on the 30th of March. So that's no longer a live issue for them. And then they go on at 91.2 to talk about procedures and parameters for the participation of legal representatives. They talk about engagement regarding availability. They talk about charge sheets, and they talk about charges not having been put to the public protector. Now, we deal in our heads of argument in some detail with the process that was followed. I'm not going to go there, but the court will have regard to page 26, paragraph 33 of our heads of argument.
Paragraph
33. No, but the court will be aware that since the founding affidavit was deposed to at the end of March, there were certain further developments that occurred. And those further developments appear in the record of Part A and Part B. The one further development is the Audi letter that was sent to the public protector. And as the court knows, that letter was sent on the 22nd of April, and she was given until the 22nd of May by which to respond to it. May I ask that the court go to the interlocutory bundle in Bundle A? And it appears at page 54, the letter. And the court will see it's I would submit with respect a strikingly important letter, because it shows that many of the prerequisites that the applicant herself identified had in fact been met by the time this letter came through. And if the court would have regard to page 55, I've just hand-numbered those paragraphs, but it's the second paragraph that I'd want to draw the court's attention to on page 55, which says, at its meeting of 22 February, the committee adopted terms of reference attached hereto, and it shows, it does include that the inquiry must be conducted in a reasonable and procedurally fair manner within a reasonable time frame. It goes on to say that the terms of reference provided further for the appointment of an evidence leader, and it refers to the names of two of our colleagues and friends who have been appointed as evidence leaders here. And then it goes on, Justices, to talk about what the terms of reference refer to. And it talks about the right to cross-examine, to call witnesses, circumstances in which subpoenas may be issued, sworn statements may be given. And then in the fourth paragraph on that page, it speaks to the scheduled time frame around revised programs being presented. And the public protector is told there that the revised program will be communicated to her. Similarly, she'll be informed of the venue and the time of the meetings at which the committee will hear evidence of witnesses, including herself. It then goes on at the last paragraph to say that, on that page, to say the present communication serves further to afford you an opportunity to respond to the allegations contained in the motion. And it then provides the electronic link to it, and it records that she's been previously furnished with a hard copy of the motion together with the accompanying evidence. And then, Justices, over the page, last paragraph, she's then told that she's requested that she inform the committee by no later than 18 May whether or not she intends using a legal advisor or other experts at the hearing, and if so, to provide the committee with their names and contact details and indicate whether they should be copied in on further correspondence. And then just perhaps the last point on that, the deadline is the 22nd of May for those submissions. So that's a significant point because it really does take care of many of these prerequisites that the applicant herself spoke to as to when the proceedings start. The second important point, Justices, is the updated program, which appears in the interlocutory bundle at page 145, which sets out the program for this committee and how and the deliverables and objectives it seeks to achieve. And the next important document in the interlocutory bundle is the invitation to members of the public, which appears at page 249. That's an advertisement to members of the public, informing them of the inquiry and where information can be obtained and public participation process effectively. And so the question then becomes, based on both the Audi letter that was sent on the 22nd of May, the revised program, and the notice to the public on the 11th of May, can it seriously be said that the proceedings hadn't commenced or hadn't started by the time the President had taken a decision? So, Justices, then if I can move on to how the High Court Part A Court determined this issue. And I'm going to ask you to go to the judgment in the matter. It appears at a few pages, but perhaps the easier one is the one that appears at page 78, Bundle B. Now, when I take the court through the judgment of the Part A court, this court will bear in mind the exceedingly high threshold of it needing to find that the findings on this issue were clearly wrong. And so, if I could then ask the court first to have regard to paragraph 106, which is how the Court A court described this challenge. It appears at page 110, para 106.
Judgment moved from volume 1 to volume 2.
I know, I've taken it out, Justice Nuku, and got it in a separate file for that reason. And paragraph 106, where the Part A court says, turning now to the proceedings argument, this is an interesting and yet curious claim by Advocate Mkhwebane. A motion was tabled for the removal of the incumbent more than 2 years ago. An independent panel investigated the issue and completed its work more than a year ago. As a direct result of this investigation, the Impeachment Committee formulated a plan of action and appointed evidence leaders. And let me pause there for a moment and ask rhetorically, this court, will this court be able to find was clearly wrong in relation to what's stated in paragraph 106? The court then goes on at paragraph 107 to deal with the approach to interpretation. And the court says to properly consider when proceedings commence, a purposive approach needs to be adopted. And the court then goes on to the matter having been overtaken. Let me pause there for a moment and make this submission. It's a trite principle that of interpretation that a purposive approach must be adopted. So the submission is that the Part A court's findings on the approach to interpreting Section 1943A cannot be faulted on that basis either. And Justices, in our heads of argument, we've provided the court with the authorities from the Constitutional Court and the Supreme Court of Appeal as to the approach to interpretation on an issue like this. The court then goes on to say at paragraph 108, if Advocate Mkhwebane is reasonably suspected of misconduct or incapacity and is allowed to remain in office, public faith in the institution is eroded. This, in turn, denudes the value of accountability. And then it asks, when can the public reasonably be concerned that allowing Advocate Mkhwebane to remain in office could and would be inconsistent with the integrity of the office? Justice Francis, it's a point you made yesterday in respect of the integrity of the office. And the Part A court said, as soon as that point is reached, the need for a possible precautionary suspension arises. Let me pause there and again make this submission. The value of accountability is one that our constitutional scheme holds dear. It was that value that this court had regard to in reaching the conclusions that it did in paragraph 108. And the submission is it cannot be faulted at all on that for the basis on which it reached those conclusions. And then, Justice Nuka, it was a point you raised yesterday about when is that line to be drawn in the sand? And the court says at 109, at the time when the matter is referred to the Impeachment Inquiry Committee, a line falls to be drawn in the sand, as there can be no doubt that the complaints against Advocate Mkhwebane are serious and could result in her removal. This is precisely when the power to suspend is triggered. And the submission is that the conclusion that is reached there is premised on the well-established principles as applied to this matter. The court has not been taken to any submission or any authority or any factual premise to show that the Part A court committed a palpable mistake when it reached those conclusions. And
was that there must be a jurisdictional fact that's present for the exercise of the discretion. Leaving aside the laudable principles that might be mentioned in the judgment, the question is, when was that point reached?
yes,
What date is it?
yes.
The referral date, when was the matter referred?
Yes. So let me perhaps deal with it this way, Justice Francis, and that is to say, in the first instance, of course, the submission is that Section 194(3)A contemplates a jurisdictional fact. The jurisdictional fact is the start of the proceedings of that committee. I don't think there's any debate between our learned friends, the Section 194 Committee, or the President as to factually where matters are and where matters stood when papers were filed. The question is whether on that factual assessment one can reach the conclusion that the jurisdictional fact for the start of proceedings has been met. And the submission is, Justice Francis, our learned friend said, extended an invitation to the parties or to the respondents to identify precisely when that point is reached. And I would submit to the court that the point is reached when the committee is in fact constituted, the Section 194 Committee, and when it actually holds its first meeting in relation to its work. It's 21 July 2021. I'm going to take the court to that in a moment. But perhaps I'd submit without putting too easy a gloss on it. The submission, though, Justices, is the court need not even go as far as that for the determination of this matter. And the court need not go there because the evidence in this matter is that the President's decision was taken on the 9th of June. And the question is, can it be said that as at the 9th of June, the proceedings had started on the 194 Committee?
Yes, but the point is, if one goes to a point raised yesterday, is that the President himself must have made the necessary inquiries to satisfy himself that proceedings had commenced.
Yes.
And so he must have something in his mind to say, yes, on this particular day, proceedings started.
Yes.
So was he of the view then proceedings started on the 21st of July,
Yes.
2021?
Yes, I'm going to take the court to the evidence on that because it's important for two reasons, Justice Francis. The first is that there's been there was a letter that was sent to the President on the 21st of July 2021 from the National Assembly, which said that the proceedings had commenced. And then the court is aware that there was a second letter that was sent on the 10th of March 2022, which said that the proceedings had commenced.
I'm sorry to
Not
press
at
you
all.
on this and persist on this matter, because if there's no difficulty from the President's point of view that proceedings commence on that date, and say that, pin one's colours to the mast, rather than say, well, it doesn't really matter, because factually, by the time he suspended the public protector, the committee already had started, or all the processes were in place as identified by the public protector. Is there any difficulty in actually pinning one's colours to the mast here?
No, there isn't, Justice Francis, but the point is this. This court, with respect, isn't seized with a question for declaratory relief as to when those proceedings have started. The question that the court is seized with is whether the declaratory relief as to the constitutionality and the lawfulness of the President's decision passes muster.
Yes, but the point is that the lawfulness of the decision is dependent on the satisfaction of the jurisdictional fact.
That is so, and I accept that, Justice Francis. I'm going to take you to the evidence on that in a moment. But the point I'm making is, perhaps I'm not making it clearly enough, but the submission is this, that the President needs to be satisfied, needs to have been satisfied as at the 9th of June that the proceedings had started. And if that threshold is met, then it matters not whether or not that decision, that threshold was met on the 22nd of April, whether it was met on the 18th of March, when the letter was sent to the public protector, whether it was met on the 21st of July 2021, whether it was met on the 22nd of February 2022, because as at the 9th of June, the case is it has been met. And I think I'd like to, or perhaps I should take the court through to our heads of argument. Can I ask the court to go to our heads of argument at page 26? And we and the court will see there we refer to the letter that was sent on the 20th of July 2021. And Justices, that letter appears in Volume A at page 486, Bundle A, Volume 5. I'm sorry, I'll come back to it, Justices.
This letter you're talking about is 21st of July.
Yes, that's right, the 2021 letter. If the court would look at Part A, Volume 5, page 486. And the court will see there's a letter dated 21 July 2021. It's addressed to the President. It's headed Commencement of Proceedings of the Committee for the Section 194 inquiry. And the President is told, I wish to advise you that the committee established in terms of Assembly Rule 154 to conduct the 194 inquiry into the removal of the Public Protector held its first meeting on Tuesday, 20th July. They've elected a chairperson, and once the Assembly has considered and debated the report, the President will be informed of the resolution. So that's strike one, Justices. Then the court's aware that we then refer to the further meeting that was held by this committee on the 28th of July, 2021, where certain aspects as to how these proceedings would be conducted were discussed. And then the court's aware that on the 18th of August, when the proceedings before the Constitutional Court were pending, there was a decision to suspend the Section 194 committee processes at that point. Justices, you're then aware that on the 22nd of February, the committee resolved to proceed with its work. This was after the Constitutional Court had delivered judgment on the 4th of February. And then at its meeting on the 22nd of February, it considered the request that the proceedings come to a halt. It resolved there's no legal basis for it. It adopted a set of terms of reference. It resolved to identify evidence leaders, and it adopted a draft program as to its working document. Then the court is aware on the 10th of March that the Speaker sent the President a letter advising him of the resumption of the proceedings. And the court was taken to that letter yesterday. I won't go there again. And then the court's aware on the 29th of March, the Section 194 committee met for a fourth time. At that meeting, it deliberated and it resolved to continue its work as per the existing program, as there's no legal impediment to do so, and it welcomed the appointment of evidence leaders. On the 22nd of April, the first Audi letter was sent through to the Public Protector. I've taken the court through that in some detail. On the 11th of May, the committee decided to continue with the inquiry, and on the 11th of May, an advertisement was published to the public as well. So, Justices, that's the history, and the submission is that when one looks at that in the context of the purposive approach to interpretation, there can't be any doubt that proceedings had indeed commenced. The submission is that the proceedings commenced when that first letter of July 2021 was sent through, but I accept it may be said that that was premature. It may be said that it actually commenced when the second letter was sent through on the 10th of March 2022. But it matters not for the purposes of the submission, because the submission is on the applicant's own version as to what shows the start of proceedings, the 6 prerequisites. Those were met by the time the Audi letter on the 22nd of April went through.
But then the purposive interpretation, does it not also require that the court must also be faithful to the words which have been used in that
Yes.
legislation? When
Yes.
it says, specifically says after the commencement of the proceedings,
Yes.
that indicates the argument was that
Yes.
it should be after the formal proceedings commence.
Well, there comes an interesting question, Justice Lekaleli. And the question, of course, is I would submit that the answer lies in the phrasing of the question itself. The Constitution doesn't reflect the formal commencement of the proceedings or the commencement of the formal proceedings. I would submit to the court that what we have is a far narrow, perhaps a far broader term that's used on it. It's the start of the proceedings. And so I would submit, Justice Lekaleni, that on the plain wording of what Section 194.3a actually requires, it says he may suspend after the start of the proceedings of a committee. And in order for this court to find that that jurisdictional fact has not been met, this court would have to find that the 2 letters from the Section 194 committee, which I've taken the court to, that the Audi letter, that the terms of reference, the draft program, the appointment of evidence leaders, all of that viewed together is not sufficient to meet this threshold of the start of proceedings. Yes.
This is really pointed that emphasis appears to have been placed on the word start or commencement.
But if you look at 194.3a, it says at any time after the start.
Yes.
So it's not confined to a specific date when
No.
the committee was convened. It could be any time.
Anytime. So all of the submissions I make, Justice Francis, are premised on that being the starting date. And so the submission is, of course, if the starting date was the 20th of July 2021, or if the starting date was the 22nd of April 2022, the point is by the time the President took the decision on the 9th of June, it post-dated those dates, and it was therefore after the start of the proceedings. Sorry, Justice Lekaleni, have I answered? Thank you. Thank you. And then, Justices, I was taking you to the judgment, the Part A judgment, and perhaps if I could just close on this point, and that's what's said at paragraph 110 of the judgment, where the court says, on the contrary, delaying the power to suspend until evidence is heard. And the court knows that in the Part A proceedings, the last ground that our learned friends referred to at paragraph 92 is they say, at best, the scheduled start of proceedings is on 4 May, and to the extent that there are any pre-trial issues before then, they don't constitute the start of proceedings. And so it's clear from that that what the argument is when oral evidence is being led. At that point, that date was the 4th of May. The argument was, well, that's the point at which proceedings have started. And to that, the Part A court says, delaying the power to suspend until evidence is heard would be inconsistent with the constitutional purpose for which the power is designed. Put another way, the very purpose for suspension exists with equal strength at the moment of critique of referral as it does when the first witness is called to testify. And then the court went on to place a substantial focus on the integrity of the office, as the court will see from paragraphs 111 going forward. So, Justices, we submit on this issue, the court, Part A court did determine it. It determined it on the basis of the principles that it applied. In using a purposive approach to interpretation, it did not deny any clear wording in Section 1943A. It remained true to the text of it. And on a consideration of the evidence that was before it, it reached the conclusion that that jurisdictional fact had in fact been met. The importance of this point, Justices, is then underscored by the President's letter of suspension. Can I ask the court to go there, please? It's in Bundle B, page 256.
That is volume 3.
We're just confirming, Justice Nku. Volume 1 of Part B, Justices, page 256. I noticed in my volume 1 of Part B of the Bundle
That
B.
can be volume 1. Our volume 1 has got Part 2. Not volume 3.
The court will bear with me for a moment. Yes,
Yes,
it is
volume
volume
3.
3. My apologies, Justice Nku. Now, I'm going to deal with this letter quite comprehensively now, so I don't need to come back to it in relation to other arguments that I'll be making. Justices, if you could have regard to paragraph 3 of that letter. Paragraph 3, Justice Lekaleni. Can I just inquire from the court? I'd noticed that my copy of it in my hard copy wasn't very clear. Does the court have a clear copy of that letter? I've got extra copies if need be.
Mine is clear.
Clear.
There are
Thank
copies that may have not been clearer, and then the
Okay.
clearer copies are requested in French.
Thank you. Thank you. So the first point I'd like to make on that letter, Justices, is at paragraph 3, where the President says, "You had asked my office through our respective attorneys for an undertaking that you defer the decision, that I defer the decision of possible suspension pending the decision in Part B. I'm not amenable to giving such an undertaking." Now, there's a quibble about whether that was Part A, Part B, but the point is the President deals with the question of the undertaking in paragraph 3. He then goes on to say he's considered each and every element of the submissions carefully, and he says that he's decided that the public protector ought to be suspended pending the finalization of the process taking place before the National Assembly. Members of the court, paragraph 6 is where he sets out his reasons for his decision. He says in the first instance, as I indicated to you in my letter of 23 March, I disagree that there's a conflict of interest. He says the public protector has not demonstrated such a conflict of interest. And he says that no litigation is pending. The mere existence of pending investigation does not in and of itself create a conflict of interest. And at 6.4, he says that if the public protector is correct, she could effectively immunize herself against processes envisaged by the 194 committee. And then at 6.5, he says the pending litigation that you refer to is neither relevant nor does it affect my power to make a decision to suspend you. He explains his position in the pending Constitutional Court proceedings, where he says he's not involved in the rescission application. And at 6.7, he says that before the High Court, you have sought an interdict to stop a number of processes. You have not as yet obtained any such interdict. My courtesy to you in recent weeks is not and never was a change in my position that no such interdict ought to be granted. As will be outlined below, my own constitutional obligations enjoin me to make this decision as soon as possible. And then, Justices, he goes on to explain various issues in some detail. And can I draw the Court's attention to 6.13, where he says he doesn't agree with the contention that the officer's work will be jeopardized by the Public Protector's absence from office. He draws attention to a very important provision in the Public Protector Act, which provides for the acting Public Protector to assume the functions of the Public Protector in her absence. And then he talks about, over the page, Justices, some of the investigations that have been referred to. And then importantly, at paragraph 7, he talks about the integrity of the office and the person. He says he had careful regard to the report of the independent panel. And at 7.3, he says that I had specific regard to and I considered the following conclusions of the panel to be highly relevant to your question of suspension. 1, the conclusions reached by the panel as regards the charge of incompetence. And there he references the time period over which it stretched. He references some of the language that was used by the courts. He speaks to some of the breadth of the errors, and he talks to the conclusion around the substantial information that the panel had before it. Over the page, Justices, he speaks to the repeated errors, and then he speaks to the charge of misconduct. And he then goes through the conclusions on the charge of misconduct on its own, and he says they give rise to prima facie evidence of intentional or gross negligent failure to meet the standard of behavior or conduct expected of a holder of a public office. And he then goes on, and I'm not going to read it all, but he then goes blow by blow as to what those conclusions were that he had regard to. Members of the Court, if I could then direct your attention to paragraph 7.5, where he then says, in light of the position you hold, there are a number of other factors I'm enjoined to consider. And he refers to the integrity of the office and the work of the National Assembly, and he says for all of those reasons he's suspending her. And so it then comes back down to this question, Justice Francis, that we were debating a short while ago about the start of proceedings. The import of this court reaching a conclusion that says, Section 1943A, when it references the start of proceedings, it means only when formal proceedings have started or when evidence of a witness is given. The consequence of that is even if the factual state of affairs prevails as set out in this letter, the public are left with no recourse until that process reaches the sufficiently late stage in order to exercise a 1943A power. And our learned friends say, well, of course that's appropriate because there are rights at stake. That might be so, their rights at stake, but there are processes that are followed in relation to those rights to ensure that they're protected. But more fundamentally, there's an office at stake, an office whose functions reside in Chapter 9 of the Constitution. So I'd submit to the court that when regard is had to all of that, the court ought to be cautious about interpreting the start of proceedings in 1943A so tightly that it's at such a late stage of the process that the effect of it is to denude the constitutional principle of accountability on it.
May well be the case, but the argument advanced yesterday was goes to the rationality of the decision. If the President had regard, and it appears he must have had regard to the report of the panel, which is in February 2021, so he knows about that. The start of the process, the formal start of the process, or he was advised, is in July 2021. Okay. What has changed since then, say July 2021 and June, that makes it so imperative to suspend? Because all the information relied on is historical.
Yes.
Does it not mean that if the integrity of the office was principal and primarily the reason for suspension, that ought to have occurred in July? Why wait all those months? And surely that must have some impact on the rationality of the decision.
I would submit not, Justice Francis, with respect, and I would submit not for the following reason. The reason is because this is a constitutional power that's given to the President. If he exercises this power later than some may contend was appropriate, doesn't denude him of the constitutional power, nor does it infuse a question of irrationality into the decision. It's a constitutional power which the Constitutional Court has said courts ought to tread cautiously on. And so the submission would be, with respect, the question is not correctly framed. The question ought to be, have the jurisdictional facts inherent in section 194(3)A been met? And if they have been met, absent any other irregularity, the decision ought to remain as one that's sound. So that's the submission on that point, Justice Francis.
That delay, and I use the term delay advisedly, in suspending, notwithstanding the existence of the jurisdictional fact, feeds into the issue which was raised in relation to bias.
Yes, I'm going to come to that. Yeah.
So there is a connection, which obviously, the President would have to explain. It may well be an explanation,
Yes.
but it does have some impact, because the reasonable member of the public informed of these facts may well want to raise a question.
Yes.
Appears to be somewhat irrational.
Yes. So,
I'm just putting it at the level of a submission that could be
I
advanced,
accept
certainly
that.
not my position.
No, not at all, Justice Francis. I accept that. Justice Francis, I think it's also important to actually have regard, as my learned friends who are more involved in the Constitutional Court proceedings than we were, but as they remind me, it's important to have regard to the timeline on this. And the timeline is that the President received the letter in June 2021 saying the proceedings have started, July 2021, saying the proceedings had started. In August 2021, there was a decision by the Section 194 Committee to suspend its process, put its process on hold, pending the outcome of the Constitutional Court proceedings. On the 4th of February 2022, the Constitutional Court gave judgment in the matter. On the 22nd of February 2022, the Section 194 Committee met. On the 10th of March 2022, another letter was written to the President saying that the proceedings had resumed. And on the 17th of March, sent on the 18th of March, the letter was sent to the Public Protector giving her ID on it. And Mr. Budlander says he will address it in more detail as well. But,
So the period of time which the President might have had is certainly not the months. It was
yes,
from the Constitutional Court had made a decision
That is
and that being relayed to him.
that is so. And so viewed as such, Justice Francis, the point then becomes a far narrower one, I would submit, with respect. Because the point is then the President is advised as to the resumption of the 194 committee proceedings on the 10th of March. On the 17th of March, sent on the 18th, he writes to the Public Protector saying, I'm considering suspending you, please give me reasons as to why I shouldn't. And the point is, and ironically, Justice Francis, even when the President takes a decision on the 9th of June, the argument we face is that it was a premature decision. If the President had taken that decision even earlier than that, we'd be in court on another very tenuous argument of it being even more premature than it was now. And so for that reason, we submit that the issue, perhaps if I can close the submissions on this basis, the first question is, and I'm not dealing with the conflict point at all yet, but the first question is whether the jurisdictional fact has been met. And for reasons I've submitted, I say that the jurisdictional fact has been met. On the question of delay, which as I understand it goes to a question of irrationality on it, I submit that a delay in exercising a constitutional power doesn't denude the functionary of that power in the first instance. And secondly, on a proper understanding of the timeline, there has in fact been no delay. So if I could then move to the last issue, I think I have a sense I may be running out of time, so must we move on? Thank you. Justices, can I inquire, is the intention to take a tea adjournment?
Yes, we'll take the tea adjournment
at 1:15. Okay, that would give me time, thank you, to deal with. The last issue on this, under this heading is the question of passing the buck. And the argument is that the President did not independently bring his mind to bear on whether the proceedings had started, and he abdicated responsibility by placing it in the hands of Parliament, the 194 committee. The first issue, and the court need not go there, but if I could just give you the reference, it's in Bundle A, page 367, paragraphs 71 and 73, where the President explains that there's a functionary called a parliamentary councillor, and in this instance it was Dr. Kernenhoff, who advises the President of certain developments within Parliament. And at paragraph 71, he explains that on 22nd February, the Section 194 Committee, it's 22nd February 2022, the Section 194 Committee resolved to proceed with its work, and Dr. Kernhoff advised him that its terms of reference were adopted. So strike one, the parliamentary councillor, who's the go-between between Parliament and the President's office, advises him of the events of the 22nd of February 2022. Strike two, the President says, and the reference, you need not go there again, it's Bundle A, page 367, and it's paragraph 73, read with BSM 6 at page 167. The President says on the 10th of March, the Speaker addressed further correspondence to him in relation to the resumption of the proceedings of the Section 194 Committee. And then, Justices, he goes on to say that he had been advised that the process had resumed and he was entitled to act on the information that was conveyed to him. He says that at paragraph 73 as well. And then if I could draw the court's attention to page 387 in Bundle A, paragraph 154, where he answers to the allegation made in the finding affidavit, and he says he took his decision after having carefully considered the factual state of matters as well as his obligations under section 194(3). And then it's interesting, Justices, it's a point I didn't raise when I dealt with the suspension letter, but let me just give you the reference. It's at the suspension letter, page 258, paragraph 6.9, where he says, "It is not with respect for me to dissect or question the National Assembly in the exercise of its powers. I have in any event considered this issue of the start of proceedings, and I'm satisfied that proceedings in terms of section 194 of the Constitution have started." So for all of those reasons, members of the court, we say that the President was in the first instance entitled to act on the information that was conveyed to him. In the second instance, he says in any event, he considered it all and he reached the conclusion that the threshold for 194(3)A had been met. And I'd submit to your lordships, in these circumstances, to ask for anything more or anything different of the head of state, it's difficult to conceive of. One asks almost rhetorically, what ought the President to have done when the Speaker wrote to him and said the proceedings have now resumed? What ought the President to have done when the parliamentary councillor, who is the go-between between Parliament and the President's office, tells him that this meeting was held on the 22nd of February and the proceedings will now go ahead? And so, Justices, for all of those reasons, we say this argument must fail. It's not a question of abdicating responsibility in relation to an administrative decision. It's a question of whether or not there was basis on which to say that the jurisdictional fact in section 194(3)A has been met, and the President satisfied himself on the basis of the evidence, as I've taken the court to show that it was in fact met. Justices, the last point on this issue is just the point around the reliance on paragraph 110 of the Constitutional Court judgment, which our learned friends place some reliance on. And perhaps I can dispose of it quite easily, and I just want to make a couple of submissions on it. The court will be aware that the submission is that if one has regard to paragraph 110 of the Constitutional Court proceedings, which is a paragraph which dealt with the retrospectivity of its order in relation to the right to legal representation. And our learned friends argue that when regard is had to that, in essence what it means is that the Constitutional Court determined that the section 194 proceedings had not started as yet. And this is dealt with in the judgment of the full court, and it's at paragraphs 114 and 115. I've got the reference at page 112, Justices.
So which paragraph?
114. Perhaps I should reference it from 113, Justice Mkhwebane.
Yes.
And at 113, the court says, in our view, the apex court in this case was not vested with or concerned with the narrow issue of the commencement of proceedings, in other words, the start of proceedings. Rather, the focus was whether the proceedings had reached the stage where the applicant would be able to exercise her right to legal representation. Put in another way, the rule denying the applicant legal representation would only arise when evidence was presented. This is a totally discrete issue from the authority of the President to commence the suspension process against the incumbent. And then they go on to explain why that view is fortified. So we'd submit that as a starting point, coming back to the principle of stare decisis, the court would have to find on this argument that the full court had gotten it clearly wrong based on the reasoning as it has. We submit that no argument's been presented on that. What, at the high watermark of the argument, has been a repeat of that which was argued in Part A. And so we submit there's no basis on which to unseat the findings in relation to paragraph 110 of the Concord proceedings. Justices, we've raised a number of other points just from an interpretative basis as to why we submit that the Concord judgment at paragraph 110 is no authority for the fact that the proceedings haven't started. But there's a further point, and the further point is this. Proceedings in the Constitutional Court were determined on the basis of an application for leave which I think went in August 2021. The court was then constrained to determine this issue in a different context, that of legal representation, and on a different temporal basis, that of timing on it. What we've got since then is the developments that ensued since August 2021 until the President took his decision on the 9th of June 2022. And the question would be, I would submit with respect, whether or perhaps a submission would be that the proceedings had moved along substantially from where it was at the time at which the Constitutional Court gave judgment. And for that reason, too, the judgment can't form a basis for this court to make a determination on that.
Should we take this?
That's a perfect time. Thank you, Justice Niku.
The adjournment will cut to adjourn until 11:30.
Did we send you such a long message about relevant performing in court? About you sitting down?
Sorry, I've just monopolized all of it.
I don't know what I was thinking, but I look sort of freshly out of the box. Yeah, true. That's quite been now. Yeah, that.
So,
Then I thought it was certainly it has a cool aid.
And I overslept this morning. Max is supposed to be at school at 10 to 8.
make these points. Point one is those cases are very different in terms of what they dealt with, the subject matter of what they dealt with, as compared with this matter. Point two is that this matter has section 2A7 in terms of the role of the acting public protector, which didn't appear in those other matters. Point three is that this matter has section 13 of the Public Protector Act, which didn't appear in those matters. And point four, the threshold requirements, and let me for a moment leave aside the Phala Phala investigation, but insofar as the rest of the pending investigations go, they don't involve the conflict between the official responsibility and the private interests. Let me then move to the next point on this section, and that is the case. I made the submission earlier on that the case made out in the founding affidavit has been made out on the flimsiest of grounds. I didn't make the submission lightly, but let me take the court to the basis for it. Can I ask the court to go to Bundle A, page 23.
Yes.
There, yeah.
Is it?
It's page 23, paragraph 53. And the court will see that the public protector raises the conflict of interest in very general terms here. She says, I'm surprised that the president has decided to issue the letter himself, knowing full well that he's disqualified due to a conflict of interest in respect of various complaints against him, which have been and or are still being investigated by me, including but not limited to, and she then identifies 4 cases, the Bosasa CR17 matter, and if I could just pause at that point for a moment, the court will know that the litigation in that matter culminated in the Constitutional Court decision on that matter. I'm going to deal with the separate EFF litigation separately in a moment. Secondly, the allegations of judicial capture. Thirdly, what I'll just refer to broadly as the SCOPA complaint. And fourthly, the use of the official airplane on a trip to Zimbabwe. And then I would ask the court, you needn't do it, you have done it already, no doubt, but if I can ask the court to carefully read through the basis for this alleged conflict at paragraphs 55 through to 68 of the founding affidavit. And the court...
55 to 68.
That's so. The court will see that the terms in which that alleged conflict is raised is on the barest of bones. So on the Bosasa matter, if I can ask the court to have regard to the president's, I'm going to ask the court to go there because these are relatively important issues. In volume 4 of Bundle A, page 329. I would draw the court's attention firstly to what the president says at paragraphs 29 and 30, which is that there's no detail given as to the premise for the conflict. And that goes to the heart of what's then the threshold against what should it be answered. The second is on the Bosasa complaint. The president speaks at paragraph 31 in detail as to some of the scathing findings that the Constitutional Court ultimately made on this. And the court will read that again in its own time, but there are many, they are far-reaching, and they are serious. The President explains at paragraph 33 that the Public Protector applied to the Constitutional Court for a rescission. That application was dismissed. And he then concludes at paragraph 34 that the position on the Bosasa litigation is clear. The Public Protector made findings against the President. The President challenged the lawfulness and rationality of those findings, as he was entitled to do. He was vindicated by both the High Court and the Constitutional Court, and the judgment of the Constitutional Court definitively put an end to that matter. The President says going forward he will bring an open mind to bear on the suspension in relation to that. Then, insofar as the new, what's called the new Bosasa litigation, which is the litigation that has been instituted by the EFF. And the court will see on that the President says, the court will bear with me for a moment. The President says that in the EFF litigation, the Public Protector was cited as a third respondent in that litigation. She didn't participate in the litigation, and in his official capacity, he had no interest in the EFF litigation. And he then makes the point, Justices, that that litigation was not the Public Protector battered against the President or vice versa, but there were two co-respondents in the matter. And if I could just draw the Court's attention to page 407, is that right? 407, yes. Where the Court will see the names of the parties to that litigation. And the Court will know from the judgment of Justice Sadiwala, which is, I think, included in the replying affidavit, I think it's in around page 1084 thereabouts, this issue, the judgment, full judgment appears there. And so the point is, Justices, you will ask whether it can reasonably be said that there is a risk of a conflict of interest in circumstances where litigation has closed at the Constitutional Court level between the President and the Public Protector, and insofar as there's pending litigation in the Gauteng High Court, the Public Protector has taken no active part in that litigation. She is cited as a co-respondent together with the President in that. And I'd submit to your Lordships there's no basis for a conflict on those facts. Justices, you need not go there, but I'm going to give you the reference in the replying affidavit, Bundle A, page 957 and following. And the Court will note that the Public Protector gives no explanation as to why a conflict ensues in those circumstances. But then, Justices, it gets worse for the Public Protector, and that's because on the claims of judicial capture, she attributes certain statements to Judge President Mlambo in the JSC interviews. And those, Justices, are dealt with in the President's answering affidavit, Bundle A, page 337. But the long and short of what the position is on judicial capture is the following. Point one, the statements that were attributed to Judge President Mlambo do not appear from the recording of that interview. We've given the Court the virtual click to go onto to listen to it, and we've transcribed what it says. And the point is, it doesn't say what Advocate Mkhwebane says that it says. Point 2 is the President says to this court that the first time that he became aware of this complaint of judicial capture was when these proceedings were instituted, and there was a letter that shortly preceded these proceedings. So it goes further than what Advocate Mkhwebane would want for this reason. There's no question of even a pending proceeding on judicial capture. It's a question of an anticipated investigation going forward. And so for all of those reasons, we say the complaint of judicial capture doesn't get off the starting blocks. Insofar as the Scopa complaint goes, Justices, that's something that's dealt with in the President's answering affidavit, Bundle A, page 343. And I'll emphasize only these points, and that's a complaint that is some 2 years old. The complaint was that the President failed to provide, my apologies, Justices, let me take it a step back. On the Scopa complaint, the complaint is, it's not 2 years old, I erred in that. The President failed to inform and provide evidence of the use of state funds for party activities. That was the complaint. The court will know from the evidence that the President has put up. He says he has no direct and specific information on this issue. Whatever was stated was through public sources, and he identifies those public sources on it. And remarkably, the public protector writes back to the President after that, and she says, well, there seems to be a veiled hesitancy on the part of the ANC to provide me with some of the information I've asked for. Would you, Mr. President, be able to assist me? And that is the high watermark of the pending investigation on the Scopa issue. Justices, on the Zimbabwean trip issue, this is dealt with in some detail at page 350 of the President's affidavit, but the point is this. The public protector sends the President a letter on the 17th of September 2020. The President responds on the 30th of September 2020, and the President ultimately says that he asked for 2 reports on this matter. He reached certain conclusions as to the conduct of the minister in question on it, and he imposed a sanction on that minister for having impermissibly used the aircraft for party purposes in circumstances where it ought not to have occurred. He says that the sanction he imposed was to deduct 3 months of her salary and to have that paid into the Solidarity Fund. That was a response, Justices, that went off on the 30th of September 2020. This in circumstances where the public protector herself says investigations ought to be concluded within 30 days. That's the statutory requirement. September 2020, and still relied on as a pending investigation in order to find a conflict of interest. And so for all of those reasons, we submit that there's no merit to any of the grounds that have been relied on in Part A. Let me now quickly move on to the Part B grounds. The first additional ground that is relied on is the Glencore investigation. I'm going to ask the court to go to Bundle B.
It does not seem as if it seems as if the applicant did not press that point much after the response was, after reading the President's response.
Yes.
Perhaps we can,
yes.
So I don't know if you have to deal with that.
Yes. I do, though, want to make this point, Justice Nuku. I believe.
I'm sorry, yes, just to assist. I agree with your lecture.
It's not a point that has been persisted.
Thank you. I'm indebted to my learned friend. Justice Nuku, with the court's leave, there is one point I want to make on that, though. And that is the statement that's made at Record Volume B, Bundle B. where the public protector says at paragraph 41,
Page number?
page 21, paragraph 41. The public protector says that the UDM wrote a letter to me as public protector requesting me to investigate whether or not the president was implicated in such corruption in breach of EMEA. For ease of reference, I annex a copy of the letter. The letter, Justices, appears at page 126 of the papers, and you will see from a reading of that letter, there is no request for an investigation. What the public protector says is manifestly inconsistent with what the letter itself says. And then the last ground, Justices, is the Phala Phala investigation. And there, the first question is the question of principle, and that is, does it meet the threshold of 96(2) because it is a risk of a conflict of interest between official responsibilities and private interests? And there I have to accept that there is a private interest at stake. It's the president's private interest at stake. And so the question is there a risk? And we submit at the level of legal principle, there is no risk because of what the Public Protector Act provides for in 2A7, and in any event because of Section 13 of the Public Protector Act. And whatever the Advocate Mkhwebane may, however she may view that pending investigation, the truth of it is the President's evidence is that he is cooperating fully with that investigation. There's no evidence before this court to contradict his statements in that regard. And so the question then becomes, Justices, with respect, can it be said that because there is a new investigation before the, in relation to the President, that now gives rise to the conflict at this stage? And we would submit to the court that the court need only have regard to the history of this matter on the timeline. And that history is, on the 10th, the letter comes in from Parliament. On the 18th, the letter goes off to the President, to the Public Protector, giving her the opportunity to make representations. And then the court knows on the papers there are many, many letters which are written about extensions and undertakings and all of that. And the only point that one can read from all of that is the Public Protector was fully apprised of the fact that the President could exercise that decision from the date on which the Audi letter was sent. And she therefore sought undertakings and everything else in order to stop or halt that. And we submit against that timeline, it certainly can't be said that because a new investigation against the President was started on the 7th of June, made public on the 8th of June, and the President then issued the letter of suspension on the 9th of June, it was a rushed job in response to that. The picture may well have been a very different one if there wasn't an Audi letter that predated that by almost 3 months to the day.
But is the disqualifying factor not the, because my reading of this section is, what does it say? Members of Cabinet and the Deputy Ministers may not act in any way that exposes themselves to any situation involving a risk of conflict between their official responsibilities and the private interests.
Yes.
So one, it seems to me that that's the disqualifying factor. Do not act in a manner that will expose you to risk of a conflict between your official responsibilities and your private interests. Now, I don't think that the inquiry goes further than that. I think once the risk, once there is a likelihood of you being exposed to risk. On the face of it, it seems to me that then the Constitution precludes you from it.
Yes, yes. But the critical question on that, and that is a matter of legal principle, is correct. That's a threshold in Section 96. But the question, Justice Nuku, is what are the factors that evidence the risk?
Yes.
And I would submit that the factors really fall into a couple of categories. The factors are anticipated investigations, because that's where Glencore falls into, and that's where judicial capture falls into. Historic investigations that have not been closed, that's where SCOPA falls into, that's where the Zim air travel falls into, and that's where...
No, I'm more concerned with the last one that you are
on the
addressing,
Pala,
Pala, because
yes.
there you say that there is a private interest at stake.
Yes.
So obviously it then talks exactly, it seems to talk to
Yes,
that question.
yes, yes.
And then with that private interest, then the president must now exercise these powers that are conferred on him by the Constitution,
Yes,
which is the
yes.
official responsibility.
Yes. Justice Nuku, the picture would be very different if it operated like this. Pala had, the investigation had happened, and the Public Protector Act provided that it was up to the President to choose who would become the acting Public Protector in those circumstances. And the President then chooses to suspend the Public Protector, and he places in her stead somebody who he has handpicked in order to do this. And if the Public Protector Act didn't make provision for the continuance of it in the way that it did, one could conceivably understand the basis of a concern for a risk of conflict. But when one has the provisions, and I don't, in the interest of time, I'm running into Mr. Budlander's time, so I don't want to belabor it, but the submission is really that there's absolutely no basis for it.
Yeah, the risk is the president's risk, okay, of a conflict.
Yes.
The fact that that risk may be mitigated because there's another person who could continue the risk, that's a different issue. As I understand the plain reading of the Act, it's whether the president faces a risk, not whether he's able to mitigate that risk.
Yes. Yes. I accept that. I accept
So,
that.
sorry, with respect, sorry to interrupt.
Not
you.
at all.
But this issue about the fact that there's an acting, or maybe an acting public protector, and the inquiry may continue, that doesn't obviate the fact that there is a risk.
Yes. Perhaps you see it slightly differently, Justice Francis. My submission is that that puts paid in its entirety to any risk, because the President has absolutely no say in relation to the acting public protector. And so it can't be used to present any risk of that power being exercised in order to advance a private interest, in order to benefit him in any way. And that's a submission, Justice Francis. Perhaps let me close on this by saying the following. So if one has regard to the timeline on Pala, one has regard to the statutory provisions that I've referred to, the submission is that there is no risk of a conflict as contemplated by Section 96(2). Justices, there is one more issue which I just want to give you the reference on, and that is there's a submission made that because the President had previously made a concession in prior litigation, that concession is dispositive of the challenge in this matter. And
but that concession was made in relation to pending
litigation, exactly. Justice Nuku, you've got the point. If I could just give the court the reference, it's Bundle A, page 358.
And in in this instance, there's no pending litigation.
There's no pending litigation, which is why it doesn't apply at all. Justices, the last point under this head is just the import of the Part A judgment on this. I'm just going to give the court the references. So, of course, Part A didn't engage with this constitutional provision, but it engaged with other aspects of conflict, and if the court can just have regard to paragraphs 95 to 97 of the Part A judgment. And then I'm going to take 2 minutes to deal with the last of the subjects I had intended dealing with, Justices, and that is just the remaining 2 complaints around the so-called agreement and around the contempt of court issues that I raised. Can I make this submission? On the contempt of court, the court will have regard to the case that was initially made out in the supplementary finding affidavit. The case was that the President received notification at 11:36 a.m. on the 9th of June that judgment would be handed down on the 10th of June.
I think the applicant accepts the
They accept
explanation by the
that.
President.
But the point, Justice Nuku, is once they accept that, and that being the premise on which Section 165 of the Constitution was invoked, it must follow as a matter of course that there's no basis for reliance on 165 of the Constitution. And therefore, insofar as the relief that is sought is premised on that, there's no basis for the relief sought. And then, Justices, on the question of the so-called agreement, we've referred in our heads of argument to the many, many letters that were written that predated the 20th of May on it. And the factual position was that the President had refused to give any undertaking. And insofar as the judgment of the High Court, the Part A Court, refers to the President having allowed her an opportunity to challenge it, etc., that's not with respect to any timeline. That is correct. The President had given undertakings. The correspondence shows that. There's a point at which the President said, prior to the hearing, no further undertakings on it. So the high watermark of the argument in relation to the so-called...
And where is that point where it was made clear that there would be no further undertaking?
Can I give you the references, Justice Nuku? I want to say page 447.
The junior has it there.
Thank you. So the one reference, Justices, is at page bundle B, page 439, where she deals with the agreement and the process, etc. And the second is at bundle B, page 447. And we quote the various letters at paragraph 76. And there's so the high watermark of the argument in relation to the so-called agreement reduces to this, that on the applicant's version, it ought to have been a 2-step agreement with no timelines, etc. There was no 2-step agreement, but the position of the President was confirmed in a single step in his letter of suspension around that. And the question then does reduce to, even, and I make no concession on that, our position is as set out in the papers, but even if there was a breach of an agreement, where does it go in terms of founding an unconstitutionality on it? And the submission is it doesn't reduce to an unconstitutionality. Your Lordships have been told, well, it points to an irrationality. I submit that no case for an irrationality has been made out on that. So, Justices, for all of
I think it's, my reading of it, it's made in this context. Here we have been communicating, giving extensions, asking for extensions, and initially there was an indication that the President is amenable to waiting until the outcome of the application, and then now there is an investigation that looms. Now the president is no longer amenable to even communicating as it had been, and the judgment is imminent. Let me just put a stop to all of this and suspend.
Yes, yes. So there are a couple of things on the facts, and
I'm
I'm
saying
running- Yes.
and my understanding of it.
No, I accept
It's not a distinct issue as such, but it's in that context.
atmosphere.
Before you answer that, perhaps you could also just at the same time address an issue which I thought you might have covered. That's in addition, the context of the Nemo Udex argument that was raised, the rule against bias. And there were two issues, as I understood, that were raised. One was on the facts that took place immediately preceding the suspension. And that was the letter to the president setting out those 31 questions. And then suddenly, use the term suddenly, because we have the suspension. And then there was the other issue that the Part A court got it wrong in relation to the test for bias when it comes to the president.
Yes.
So perhaps you could address those things.
Sure. So, Mr. Budlinder, and I'm very conscious of eating into his time, Justice Francis, so he's going to deal with the issue of the test, so if I may defer that to, or hand that point over
It's
to
not the
him.
DA that was, that the argument was made against the president.
Yes. Justice Francis, let me do so. I'm just conscious of time around it, but the first point, perhaps let me start by Justice Nuku's question.
We'll ask Mr. Mpofu to be kind when it comes to his time so that we can shift a little bit.
Thank you.
No, I'm saying that we'll ask you when it's your time to speak, to borrow some of your time, perhaps we can compensate with it later.
Okay.
Because this is a very important point that I think we should.
Quite similar. And I also have the extra time that was given to me by Mr. Masuku, so I can give some of it.
Thank you. So the first point, Justice Nuku, is one of fact. And the question of fact reduces to this. Can I ask the court, given the relevance of it, to actually go to Bundle B, Volume 5, page 447. And Justices, what that does is that we set out in some detail what the President's historical position was. So there's a letter that we refer to at 76.1, which is a letter of the 12th of May, my apologies, where the President says at paragraph 5, at that date, the date of the 26th of April has now passed, and as you are aware, no further undertaking has been granted since then. The President is not amenable to granting the Public Protector any further undertakings in respect of him taking a decision on whether to suspend her or not. Paragraph 6, the underlined portion, the President has decided to afford the Public Protector until 20 May by which to respond to his letter. In a further letter of the 14th of May 2022, the following was said: it confirms the agreement between Council. They'll afford the Public Protector until 26 May by which to respond. In the event that the Public Protector responds by 26 May, the President will carefully consider her response prior to taking any decision. In the event that she doesn't, a decision will be taken in the absence of a response. In a letter on the 16th of May, 2 days before we went into court on this matter, the State Attorney wrote again, saying the earlier promise or undertaking as alleged is denied. The President's position is clearly and consistently set out in his answering affidavit and in previous correspondence, more particularly in our letters of 23 March, 25 March, 31 March, and
We can
14
read
May.
the quote. I think just make the point that you
Yeah.
want to make.
And the point is, he says, for the avoidance of any doubt, we reiterate there is no undertaking or promise in place. So, Justice Nuku, the point that you put to me, which is to say, well, historically he was far more amenable, and suddenly there was the shift. The submission I make is
It's
that...
not factually correct.
It's not
because It's
factually
demonstrated by this.
Correct. That is so, yes. Justice Francis, on the points that you had raised, on the Nemo Judex point, as we see it, it's the following. The judgment in, no, perhaps let me reframe it. The issue around conflict of interest reduces to three issues. The first is actual bias. The second is a reasonable perception of bias. And the third is the conflict under Section 96. The Part A court found that there was no basis for actual bias, and the submission is that there's been no argument advanced to the court to suggest otherwise. Insofar as a reasonable apprehension of bias goes, the Part A court found that it is in fact the double reasonable test that applies. And I would submit to the court that there's no argument, certainly as we understand it, that shows that and I accept the principle that what it does is it extends to the President the principle that would in the ordinary course apply to judges. But the submission is that there's no basis on which to suggest otherwise, in other words, to contend that the court, Part A court, was clearly wrong in reaching that conclusion.
If the principle is wrong, if the President doesn't enjoy the same type of protection, if you want for a better term,
Yes.
as judges, then Part A
Yes.
court must have been clearly wrong.
Yes, but Justice Francis, it does reduce to this, though, if the test isn't that of the test as it applies to judicial officers, as set out in the case law, I haven't heard a submission as to what the appropriate test is.
Well, the appropriate test would be everything that doesn't apply to judges, namely a reasonable apprehension test.
So, and if it is, then I would submit that when the court looks at reasonable apprehension, then the court must in any event be guided by what Section 96(2) says. One can't look at reasonable apprehension in a vacuum when it comes to a functionary whose conflict issues are expressly regulated by a constitutional provision. And it does then reduce to Section 96(2) test on that if the court isn't to go with confirming what the Part A court said on that.
No, I haven't formed a view on this. All I'm saying, this was pertinently raised by the applicant yesterday that the wrong test was used.
Yes.
And it was one of the bases that it was argued that Part A judgment was wrong.
Yes.
So I just
No, I'm
wanted
grateful
the
for that.
President to perhaps respond
Yes.
to that. Because if that is a correct argument, then it means at the very least on one point, the Part A judgment was wrong.
Yes, yes, yes.
And it may well have an effect, because a reasonable person may not be aware of Section 1 of 96 and the conflict of interest issues. A reasonable person might well look at just the objective facts, and it's an objective test at the end of the day. So it is quite important what the test is.
Yes. I appreciate that, and let me answer it this way, Justice Francis, and that is submission one is I submit that there's certainly no authority that we've been able to find on this, so it's completely novel ground. I would submit that an extension of the principles that apply to judicial officers ought to find application in the present instance, and for that reason the submission is that the Part A court was not clearly wrong. In the
You
alternative...
say that the presumption that applies in respect of judicial officers should apply to the President.
Yes, yes.
And is there any authority for that you can assist
Yes.
us with?
No, so Justice Snooker, I prefaced it by saying I certainly haven't been able to find
Okay.
any authority on this point at all.
Okay.
So it's entirely novel ground on it. yes.
Oh, I'm sure Mr. Badlander will.
Yes.
He's nodding.
He's waiting to do it, so, and I'm getting...
So the DA will come to the rescue. but on a serious note, it's quite an important issue, because if the president is to enjoy the same latitude as when a judge is placed under scrutiny so far as bias is concerned, then why the president? Could be cabinet members, could be the PP, it could be anyone in a higher level in government. But why the president then? Perhaps you could suggest why the president.
Well, perhaps let me take a step back on this, Justice Francis, and let me say the following. The starting point is, of course, Section 96 of the Constitution. And I would submit that as a departure point, that really does set the test. Step 2 is what the Public Protector Act says in Section 13 in relation to this issue. And it seems to me that this court is going to have to carve out a cautious and a conscious test in relation to the president. And I submit when the court does so, it ought to be mindful of what Section 96 actually does provide for on that. And so I can't take it any further than that. That is the submission. But the point is really does come down to this, and that is that the submission is on the evidence that has been placed before court. The threshold, whether it's under Section 96 or whether it's under common law, has not been met on it. That's the primary submission. Justices, just on the last question of costs, the Public Protector seeks costs personally against the President. There's no case made out for that at all in the Part B proceedings. We submit there's no basis for it, and we ask that the application be dismissed with costs, including costs of 3 counsel. I'm indebted to the court.
I just only had one question that I wanted to raise, particularly in terms of Section 165. I'm still not that clear on the argument that was raised that whilst the President was aware that a judgment is to be given, and that judgment specifically related to the very same issue of suspension, but notwithstanding that, the President went on to suspend the Public Protector.
Yes.
Is that not in conflict with Section 165, subsection 4 in particular?
Yes. I would submit not, Justice Lekeleni, for this reason. Firstly, there was no undertaking in place from the President's side on that. Secondly, the matter had...
Leaving the undertaking aside,
Sure.
but just for the fact that it is known that judgment is imminent, because you can understand the record of proceedings of the previous sitting, there was an undertaking that judgment will be given eminent, I think within 2 weeks or a week or so.
Yes.
And that judgment was going to deal specifically with the question of suspension.
Yes. Yes.
Now, notwithstanding that knowledge,
Yes.
The President went on to suspend.
Yes.
Is that not in conflict with his responsibility
Yes.
as far as Section 165 is concerned?
Yes, I would submit not, Justice Lekeleni, for these reasons. The facts are these. The President had no idea as to when the judgment would be handed down. At the level of legal principle, we've referred the court in our heads of argument to City of Tshwane versus AfriForum. It's a constitutional court judgment, and we referred in particular to paragraph 72 of that judgment, where the court said that simply by virtue of instituting an application or even arguing it doesn't have the effect of, in effect, interdicting certain conduct. And the court said at paragraph 72 that the applicant was required to satisfy the court that the respondent counsel knew that the interim order was certainly going to be granted, and its expeditious execution was intended to frustrate the enforcement of the anticipated court order and thereby defeat the course of justice. And that is the Constitutional Court's threshold for defeating the course of justice, where action is taken pending and awaited judgment from a court. And I'd submit on that test, which this court is bound to apply, one doesn't get to a breach of Section 165 of the Constitution. Thank you. Thank you. I'm indebted to the court, and I apologize to my learned friend.
The Parliament has been eagerly waiting.
Lords, if you speak to my family, you'll know it's hard to keep me quiet for too long. They would have been very impressed that I stayed quiet. Justices, members of the court. It's necessary to begin for a moment by explaining the role of the DA in these proceedings. Because Justice Francis quite rightly said, I know in a joking vein, is the DA going to help out the President? But you might legitimately have a question. Why is the DA here with such fervour? And the reason is that the DA is the party that sponsored the impeachment motion. It is the DA that started the impeachment proceedings against Advocate Mkhwebane, and it is the DA that has been clear in its papers before the court that it is of the view that Advocate Mkhwebane needs to be suspended. Now the DA has no complaint lodged against it before Advocate Mkhwebane. There's no suggestion that the DA is doing it to protect the Premier of the Western Cape or the MEC for Health in the Western Cape. It's got nothing to do with that. The DA is of the view that the findings of courts make clear that Advocate Mkhwebane is unfit to continue holding this office. The NA has referred that to the 194 committee, and the DA is of the view that once that is the case, Advocate Mkhwebane should be suspended. The President has made his decision, and Advocate Mkhwebane is now trying to undo that decision on what I'm going to submit are a series of contrived and unsustainable grounds. And that is a matter of extraordinary concern to the DA. But can I say, Justice Nuku, members of the court, that I want to begin after that context by doing something I've never done. I want to read you a list of judges. Justice Saldanha, Justice Steyn, Justice Samela, Justice Bartman, Justice Dolamo, Justice Nuku, Justice Madlanga, Justice Madondo, Justice Majit, Justice Mhlantla, Justice Pillay, Justice Rogers, Justice Turon, Justice Tlaletsi, Justice Chiki, Justice Kolopin, Justice Matopo, Justice Mlambo, Justice Unterholter, Justice Erasmus, Justice Dolamo again, and Justice Villa. Those are the 21 judges, 21, who have found that the PP's, Advocate Mkhwebane's challenge to the parliamentary proceedings via the rules cannot help her. The first three judges, Saldanha, Steyn and Samela, dismissed the Part A challenge. The next three judges, Bartman, Delamo and Nuku, dismissed 10 of the 12 grounds that Advocate Mkhwebane sought to bring to the rules. The next 9 judges unanimously dismissed Advocate Mkhwebane's cross-appeal to the Constitutional Court on those 10 grounds. The next 4 judges, Justice Kolopin, Matopo, Mlambo and Unterholter, were part of the bench that dismissed rescission 1, the attempt to dismiss the court's rescission. The next 3 judges, Justice Erasmus, Delamo and Villa, dismissed the attempt to resuscitate that in Part A. Those 21 judges have said, whatever else you may have going for you, Advocate Mkhwebane, your case that the rules are invalid on those 10 grounds, those 21 judges were unanimous that that point had no prospect. And yet we stand here before you, and those grounds are still advanced. Because make no mistake, that is what the parliamentary proceedings part of this case is about. You are asked to say that the parliamentary proceedings are invalid because they are proceeding in the face of rescission 2, Rescission 2, which seeks to rescind the order, rescinding the first judgment, refusing to rescind the first judgment. The first judgment, which dismissed the appeal against Justice Nuku and the other judges, dismissing the 10 grounds. You are asked, effectively, to second-guess 21 judges who have unanimously held that the parliamentary proceedings can take place and are beyond reproach. Now, that is an extraordinary thing. And it's doubly extraordinary when you add in the other judges who Advocate Mkhwebane tries to take down with those 21. She says that Chief Justice Zondo was part of the conspiracy against her, together with the President and the Speaker. She says that Justice Mpati did not fulfill his obligations when he carried out the investigation into the Abramji issue. It is the most extraordinary spectacle. And the reason it's extraordinary is because you are faced with a litigant who is prepared to take any point at all, in order to try and protect her self-interest. Now, I'm going to come to the individual points on the merits. But when you consider those individual points, I'm going to ask you to remember that these are points which are raised by a litigant who will change her case at the drop of a hat, and you have to ask, with respect, is this case brought bona fide? Or is this just the continuation of an extraordinary Stalingrad strategy to try and prevent her from being suspended with pay, and ultimately potentially removed, depending on what Parliament might say? And I would say to you with respect that you need to take into account that I have never seen a case in which 4 full benches have had to consider litigation between the same parties. 4 full benches. The Constitutional Court 3 times, because it was the application in leave to appeal in Part A the first time round, it was the appeal in Part B, and then it was the rescission of the appeal in Part B. Now there's the rescission of the refusal to rescind in Part B. So it's 4 times. So it's 4 full benches and the Con Court 4 times, considering a single case. It is extraordinary. And when my learned friend summarized, he left out perhaps the most embarrassing aspect of his client's campaign. He didn't make reference to the African Commission, because you will have seen from the papers, Bundle B, Volume 4, page 332, you will have seen that Advocate Mkhwebane, having lost in the Con Court in the proceedings, proceeded to approach the African Commission on Human Rights, alleging that the Con Court had violated her rights, and saying that she had exhausted all internal legal remedies. And just weeks later, she was launching more proceedings in the Con Court to rescind, never disclosing to the court that she'd gone to the African Commission, never disclosing to the African Commission that she'd gone to the court. This is not a bona fide litigant. This is a litigant who will do whatever it takes, and until now has done whatever it takes at taxpayers' expense, all funded by the taxpayer, all of it, until, and you've heard the debate, and I'm not going to get into it, but until the partial withdrawal of funding. All of it funded by the taxpayer, no matter how hopeless, no matter how spurious, all for the object of delays. And I can only commend to you what the Con Court said in paragraph 104 of its judgment, delivered earlier this year, where it dealt with Advocate Mkhwebane's submissions on remedy. And what it said is that her...
In which matter is that?
Well, that's the problem, I'm sorry. It's the judgment on 4 February 2022.
In the 4th of February.
4th of February. It's in the appeal from your matter, Justice Nuku. On the 4th of February, in paragraph 104, where the public protector had tried to say, even if she won on the legal representation point, which she did, it should be remitted back to the High Court, to the National Assembly, for the rules to be redrafted. And the court said, I disagree. This can only be interpreted as a tactic to delay the proceedings. As in a public protector's own written submissions before this court, she argues for the rules to be severable to the extent of the alleged excess. The public protector therefore recognizes that severance is suitable when it counts in her favor. So in other words, it's just a case of delay at all costs. You say severance when it suits you, you say no severance when it doesn't, you say no remittal when it suits you, you say remittal when it doesn't. It's just as you like. And this court, in the full bench judgment, in Part A here, said a similar thing in paragraph 148. This court said, that of course was Justice Erasmus, Delamo, and Villa, said unanimously, it is so that the papers presented by Advocate Mkhwebane are replete with some ruinous allegations against the parliamentary respondents and against the presidential respondent. From an evaluation of the evidence presented in the papers, regretfully it seems apparent that she has been less than candid on many occasions during this unfortunate litigation between the parties. And what I'm going to take you to is the fact that the arguments which were advanced yesterday, some of them bear absolutely no relation to the facts on these papers, none whatsoever. And so the tactic of making any legal argument, whether borne out by the facts or not, is regrettably continuing. To say that one judge is biased against you is something. To say that a full bench is biased against you is another. But to say that the judiciary is involved in a conspiracy against you and that 21 judges across 2 courts have all got it wrong and you've got it right, that is an extraordinary statement. Now, against that backdrop, I propose to deal, if I may, with 5 issues. First, I want to deal briefly with the question of whether the proceedings have started. Secondly, I'm going to deal with the question of timing, the chronology, which was said to show bias. Thirdly, I'm going to deal with the bias point itself in relation to the litigation and the investigations. Fourthly, I'm going to deal with the contempt point and the contract point. And fifthly, I will deal with the costs. And in doing so, I would ask you to bear in mind, as I've already said, that I'm here for the DA, I'm not here for the President. The DA has been sharply critical of the President's conduct with relation to Phala Phala and has called for parliamentary investigation. So I hold no brief for the President. But the DA's position is to say that the Phala Phala issue, as serious as it is, cannot be allowed to obscure Advocate Mkhwebane's wrongdoing and the need for her to be suspended and the fact that her suspension was lawful. So I will ask you not to ask the question whether Phala Phala matters or not. Of course it matters. But the fact that it matters doesn't mean that Advocate Mkhwebane was unlawfully suspended. The two things just don't follow. I'm not going to deal with the parliamentary proceedings any further because I think 21 judges is enough, and I think that my learned friend Mr. Breitenbach has dealt with that adequately. And so I'm now going to I'm going to focus on the presidential suspension. So firstly, on the question of whether the proceedings have started, we deal with that in our heads of argument at page 27 of the heads. I will not read the heads, but I wish to just make 2 brief points. Justice Francis put the question to our learned friend Ms. Pillay, well, when do you say that the proceedings started? Justice Francis, on behalf of the DA, we have 2 submissions. Our submission last time, which we persisted, is that the proceedings started when the matter was referred to the Section 194 committee. So it was that in fact, if I can just get it right for a moment, yes, that was in fact March of 2021. So
Mr. Mpofu was right when he said that if you give parties a paper
yes.
and then you say they must put in a date when the proceedings
yes.
started.
He was right on that, but where he was wrong is to say extraordinarily that they haven't yet started while evidence is going on down the road. So with respect, the DA's position, and I don't shy away from it, was that it started in March, but the DA's position was also, and that was the position that was accepted by the High Court in Part A, was that at the very latest, it had started by the 20th of July, which was the day that the Section 194 committee held its first meeting. So the answer to your question, Justice Francis, is we say, because of the need to give the President a suspension power, it should be March, because that is the date on which it was referred. But for present purposes, it makes no difference, because at worst for us, it started in July, on the 20th of July, when the 194 committee held its meeting. And I don't shy away from that. I'm trying to advance a principled position, not simply cut my cloth to whatever might suit my client, because we're trying to help and give the answers. So that's the answer to Justice Francis's question. And the only other
the start of the proceedings is when the matter is referred to the committee.
Exactly. In the same way as the start of proceedings is when a matter is lodged in a court, we would say that's the start of proceedings. That's how we got to that conclusion, and we explained that to the Part A bench. But we accept that there is a different world in which you can say the start is only when the actual meeting starts, like when a hearing starts, and in that event, it was the 20th of July. But in either event, nothing turns on it because, of course, the suspension only happens a year down the line, and I'll come to that timeline in a moment.
But the drafters of the Constitution would not have said that if that was intended by the Constitution, that at the time when the first committee met, that would be the start of these proceedings. Would they have not crafted it that way in the Constitution, if definitely that was the intention of the legislature?
Well, with respect, when the drafters met, they didn't know whether the proceedings were going to involve evidence or whether it might all be dealt with at one meeting, etc. So that's why they say the start of the proceedings, and it could be that there might be some circumstances where no evidence is necessary, where there's just a meeting and at the meeting everybody knows what was done and they just take a decision. So the start of the proceedings is when the committee starts doing its work on that version. And whether they do that work by meeting, by agreeing on an agenda, by appointing evidence leaders, or by hearing the evidence, that's when it starts. It starts when they start doing their work on that reading. But so at the latest, it was the 20th of July.
Is that the purposive interpretation, if I understand, is that...
It is, indeed.
Yes.
Because, sorry, Justice Lukuleni, I was taught you should never put a question to a judge, but I understand the question to be, would it not be later when the actual evidence is being led?
Yes.
But with respect, the trouble with that, and that was debated at length before your brothers in the previous matter, is if you wait until the evidence is led, it's too late. Because then what you're doing is you are allowing the public protector or the head of the, or the Auditor General or the head of the Electoral Commission, because of course it applies to all of them, you're then allowing them effectively to intimidate witnesses, because you're saying until that first witness is called, nobody can suspend you. You're closed with your powers, you can intimidate the witnesses, etc. It would be far too late to say only when that first witness gets in the box can you be suspended. Until then, you can have a cloud over your head and it's just too late. So,
is that not a consequence of the Constitution?
No, but with respect, the word is the start of the proceedings.
Yes.
And the start of the proceedings can be given different meanings. I accept that. But you must give it with respect to purpose of meaning. And the purpose of meaning is to enable the President to protect the process. And the reading that best enables the President to protect the process is to say that it starts either when the matter is referred to the 194 committee, because then everybody knows this is a serious matter, there's a prima facie case, they're onto it, or when at least the 194 committee is constituted and has its first meeting. Because both of those things prevent the problem of the public protector or the head of the Gender Equality Commission or anyone else interfering with the process. If you wait until Mr. Smith or Ms. Smith gets in the box, it's too late. Witnesses could have been interfered with, there could have been months that have passed, the whole thing could have been imperiled. So to say to the President, you don't even have a power until that witness gets in the box would fundamentally undermine the purpose in my submission. And that's why we submit that the full bench was undoubtedly right in its conclusion that it reached. The start of the proceedings could be given, those might be able to be given the different readings linguistically, but purposively, it could never be only when the first witness is called. The other question which I just wish to deal with on this score is, of course, we know what has now happened. Last time round, our learned friend for Advocate Mkhwebane argued the proceedings start when the first witness is called. That was last time's argument, because at that point no witnesses had been called. Now the argument is, no, that's no good, not right anymore. Now the argument is actually, these are not removal proceedings at all. The proceedings still haven't started, even though we've all witnessed the spectacle of the witnesses and the cross-examination. Now you ask yourself, why has that changed? Well, it's changed because obviously, if the proceedings hadn't started when the suspension happened, but they have now, then the obvious remedy would be to say, well, the jurisdictional fact is now satisfied, and so the just and equitable remedy is not to set it aside. That's the obvious remedy that would occur. So now the public protector changes her case. Now we get the extraordinary argument that this committee is not it's not a removal committee at all, and that in fact there are two different committees contemplated by 194. Now, when that argument is put, not only is it so self-evidently self-interested on behalf of the public protector, but when this bench says, once, twice, or three times, but Mr. Mpofu, what would be the reason for that? And what would the purpose be of this? The court kept getting the answer, I don't know. At least twice, our learned friend said, I don't know. Well, that just demonstrates how, with respect, untenable the argument is. If you advance an interpretation of the Constitution and you're asked, but what would the purpose be? And your answer is, I don't know. That just demonstrates that the interpretation can't be tenable.
Was he not saying that it appears that there's a lacuna, there's a gap, which apparently is a responsibility of the National Assembly?
But with respect, you don't interpret the Constitution through the rules. You start with the Constitution, and the Constitution can't be, the Constitution has only one meaning. It can't change depending on what the rules say. And that Constitution speaks of one committee. And this is the committee envisaged by the Constitution. And if you want to attack the rules, you must do so, as this public protector has done. But you can't, with respect, say, well, now because of these rules, there's a constitutional problem, and then do it without doing it. It simply doesn't work. So we persist in saying that the proceedings have plainly started, and that this last attempt to come up with a new argument is untenable.
Mr. Mkhwebane argued that, in fact, the Constitution envisages two committees.
Yes.
So not just one.
Yes.
The first committee is the committee that makes a finding to the effect. It's 194, 1B. A finding to that effect by a committee. I think the emphasis was on A, not the.
Yes.
Because if it's referred to the same committee, then maybe in paragraph 3A it would be the committee. So he says there's two.
Yes. That's the argument. But with respect, it's utterly, it serves no purpose. What would be the point in speaking of two committees under 194? One committee to determine whether something has gone wrong, and another committee to determine removal. It simply makes no sense. And when you asked him, Justice Francis, what would be the point of that, the answer you were given is, I don't know. And that's because there is no purpose. There is an obvious purpose in saying there is one committee. That committee will look into whether the head of the Chapter 9 institution has committed wrongdoing and will recommend removal. Because, of course, they could conclude, well, there's been wrongdoing, but the wrongdoing is not sufficiently serious to justify removal, and so we do not recommend that. And it makes sense to have that same committee doing so. And it makes sense to link the suspension question to that committee, because that committee is the body that's dealing with it. So that all makes perfect sense. And that's the way we all argued it last time. But now, because the shoe pinches, because the first witness has been called and the first cross-examination has occurred, now because the shoe pinches, we get this argument that there must be two committees, but without any justification or any purpose. With respect, that is the argument that was advanced, but it's utterly untenable at the level of logic. So could I now turn, Justice Nuku, if I may, to the question of timing? Because I must say, I have a theory that when you sit and hear your opponent's arguments and they strike you as worrying, then one of two things has happened. Either you're losing the case, or your opponent is getting the law wrong, three things, or your opponent is getting the facts wrong. Well, I had that feeling yesterday, because when I heard my learned friend say, well, what took so long from July 2021 until June 2022, I thought to myself, that sounds like a good point. But when you actually go and read the chronology, which I'm going to do with you now, it is a point that is utterly unmoored in the facts. And the public protector must know that. And the point is patently bad. Could I ask this court to go to the chronology of key events, which is attached to the speaker's heads of argument? Because one thing you'll say about Mr. Breitenbach is he always produces a chronology, and it's always very detailed. And it's very helpful if you are not a chronology-oriented person like myself. Could I ask you to go to the third page of the chronology, and I want to carefully work through it, because the argument you will recall was you could have suspended on your version since July last year. You only suspended a year later. So the only inference that can be drawn is that it was a retaliation for Pala Pala. That's the argument. And the argument is utterly untenable, and let me explain to you why. And I apologize for covering some of the ground Ms. Pillai's covered, but it's an important point because it received such a focus. You'll see halfway down the date of 21 July 2020. That is the date on which the Section 194 Committee holds its first meeting. It elects its chairperson, and it writes to Advocate Mkhwebane telling her that the 194 Committee has had its first meeting, and it writes to the President, informing him that the Section 194 Committee has had its first meeting. So that's the starting point, if we accept that it's the first meeting, which is the way that the President has understood it. So you would think that's the starting gun. But of course, a week later, and you'll see that at the bottom of the page, something else happens. A week later, this court's predecessor, delivers its judgment in Part B, and it declares two of the rules invalid. One of them was the legal rep point, which of course could have been cured going forward, but the other was the inclusion of an independent panel, including a judge. Now that was potentially fatal, because if that challenge had ultimately been upheld, then the whole process had to be started again, because it would have meant that the use of the independent panel was invalid. So that judgment potentially threw a spanner in the works for everything, and I think we all accepted that that was the debate. And so what happens just 2.5 weeks later? So the judgment comes down, and so 2.5 weeks later, over the page, top line, on the 18th of August, the acting speaker applies for leave to the Con-Court, and in his affidavit, the acting speaker says, I have recommended to Mr. Dianti that the Section 194 proceedings halt, the Section 194 committee halts its proceedings. So at that point, the proceedings might have started, but they've now stopped, because everyone accepts. And if they hadn't done that, Advocate Mkhwebane would have applied for an interdict, and she would have got it, unquestionably, because at that point, everything stops. So the President, notionally, could have tried to start suspension proceedings in the last week of July, but of course then we get the Part B judgment, and then we get the application for leave to appeal 2 weeks later, so it stops. So there's no delay there, there's no inexplicable, unexplained delay, it all makes perfect sense. Things are held in abeyance. They're held in abeyance while the Con-Court considers its judgment, and the Con-Court delivers its judgment, you'll see it in the next block down, 4 February 2022. And so the Con-Court gives its judgment, it upholds the legal rep point, it dismisses the point about the independent panel, it dismisses the other 10 grounds, and that creates space for the committee to proceed again. So now, legally, there is space for the committee to proceed. But of course, the President's not going to jump the gun, it's not his committee, he's not in control of it. And so you've got to go all the way down to 22 February 2022, and you'll see there, that's when 2 weeks after the Con-Court judgment, the 194 committee meets, and it resolves to proceed with its work despite Advocate Mkhwebane's threats, and it decides we're going to get going again. And on the 10th of March, because in the meantime there's correspondence flying back and forth, on the 10th of March, the Speaker writes to the President, that's the next block down, and says, we're advising you that we've resumed work. So now the ball is back in the President's court. If he wants to think about suspension, he can think about it, because it started work again. That's the 10th of March. Now what happens on the 11th of March? Advocate Mkhwebane launches her application to rescind the Con-Court judgment. That's rescission 1. But the President is undeterred. He says at the end, and you'll see this in the last block, on the 17th of March, he writes to Advocate Mkhwebane inviting her to make representations as to why he should not suspend her. So is there a delay there? Well, of course not. The President has written calling for submissions, and he's done so a week after the Speaker wrote to him saying, we started again. So there's no delay there either. On the 22nd of March, and that's not in your timetable, I have finally found a flaw in Advocate Breitenbach's chronology, but on the 22nd of March, if you could add it at the top, on the 22nd of March, there is a letter written by the Public Protector's attorney to the President. The reference is Bundle A, Volume 2, page 262. And it's a letter which says, please don't, I'm summarizing, please don't do anything about suspension. You are conflicted, and I'm bringing an urgent application, and I don't want you to do anything until that urgent application is over. There is correspondence back, sorry, I should have said, that 17 of March letter said Advocate Mkhwebane had until the 31st of March to make her submissions. So she gets given until the 3rd. So you can't take a decision before the 31st of March, but then the 22nd of March comes this letter. And then on the 31st of March, the very day on which the submissions are due to come in, instead, Advocate Mkhwebane launches Part A of these proceedings. So we've got Part A of these proceedings which are launched. And then we know there's a backwards and forwards, and there's an undertaking. We won't make this. The President says he won't do anything at some point. And then we had the first hearing in front of Justice Erasmus, and we had the Ismail Abranji debacle, and then we had the second hearing in front of Justice Erasmus. But in the meantime, there's a backwards and forwards, which I'm not going to get into, because Advocate Pillai's dealt with it. But in the meantime, eventually, on the 26th of May, 2022, and that's not in your timetable either, but on the 26th of May, 2022, you'll see that the Advocate Mkhwebane makes her submissions to the President about suspension. And you will see that in Bundle B, Volume 1.
Isn't that in page 7 of that chronology? Is it not the same? Page 7 of the chronology.
I don't see the submissions.
Further letter by Sienna.
But that's to Mr. Dianti.
Oh, I see.
Yes, I also thought that. No. But these are the submissions to the President. So this is Bundle B, Volume 1, page 28, paragraph 65. So has there been any delay up to that point? Well, obviously not, because remember, just to retrace the steps, there was the letter from the Speaker to the President on the 10th of March saying we've started again. 7 days later, the President calls for submissions, and those submissions are only made for a variety of reasons on the 26th of May. The President doesn't want to make a decision before the submissions are made, so it's only on the 26th of May. And ultimately, of course, as you will see over the page, on the 9th of June 2022, the President makes his decision suspending. So the delay, if there were one, is a delay from 26 May 2022 to 9 June 2022. That, by my count, is 14 calendar days. That's obviously not a delay. He had to consider the submissions. So this suggestion that there is a delay of a year, and that argument was advanced vociferously yesterday, is an argument that is utterly unmoored in the facts before you. And Advocate Mkhwebane must know that it's unmoored, because she knows all of these facts. And yet the argument is advanced. So we say with respect that the delay point is just untenable, and it fundamentally misrepresents the common cause chronology of facts that emerges from these papers. Now, what explains the reason that the argument is advanced? And here we come to the elephant in the room. We come to Phala Phala. Because what happens, we know, if I can just go back to the chronology, the 26th of May. So the President first, and I'm going to emphasize this because it's important when we come to the conflict of interest point. The President initiates these proceedings, suspension proceedings, on the 17th of March. That is almost 3 months before anyone in this room has ever heard of Phala Phala. 17th of March. The Public Protector makes her submissions on the 26th of May, 2022. That is days before anybody in this room has ever heard of Phala Phala. Whether by coincidence, whether by design, whether by fate, on the 1st of June 2022, Arthur Fraser lays his complaint at the police station about Phala Phala. That's not me speaking, that is the papers. It's Bundle B, Volume 1, page 21, paragraph 42. On the 3rd of June, 2 days later, with remarkable speed, the ATM, who is represented here, or was represented here yesterday, the ATM writes to the Public Protector and says, please investigate. That's Bundle B, Volume 1, page 23, paragraph 46. And 4 days later, on the 7th of June, again with remarkable speed, the Public Protector sends a list of 31 questions to the President. That's Bundle B, Volume 1, page 23, paragraph 47. Now just let's take a step back. If I had told you, absent any mention of Pala Pala, my lords, that the President had taken from the 26th of May, when he got the submissions, until the 9th of June to make his decision, you would have said, that is unremarkable. It is not a delay. It is not rushed. It is doing what any good president would. He's considered the submissions for 2.5 weeks, and he's acted expeditiously but thoughtfully. But what the elephant in the room is that merely because of an intervening event, which nobody knew about when this process started on the 17th of March, which nobody knew about on the 26th of May, where Arthur Fraser lodges that complaint on the 1st of June, the ATM responds with speed, the PP responds with speed. Now we are told that this suspension is purely retaliatory. It is purely an attempt by the President to get rid of the public protector off the investigation. That is the argument now advanced.
That's one part of the argument.
I'm coming to the rest, I promise. But that's the argument that's advanced. Even though we know that the investigation continues, even though we know that the Deputy Public Protector refused to give the President an extension and said she was going to subpoena him, even though there's nothing in these papers to question the integrity or the credibility of the Deputy Public Protector, we are now asked you are asked to say that this suspension was a suspension decision taken by the President purely for purposes of retaliation. That is an inference and a conclusion that you, with respect, simply cannot draw from these papers. And I'm going to come in a moment to why, by dealing with the test. And Justice Nuku, I'm not running away from it. But before we get there, we've got to get the chronology right. And the chronology points away from bias. It points away from retaliation. It points, and I can't believe that I'm saying this on behalf of the official opposition, but this points to a president who, in this case, was doing his job. That's what it points to. So can I now turn to bias, and can I deal with the question of bias? And that's the third topic. Can I spend a moment on the test? But in doing so, I want to say that the test doesn't really matter. And I'll explain why in a moment. I accept that the test matters as to whether this court is at large relative to the Part A court. But whether you apply a double reasonableness test, which is the one version, or a single reasonableness test, which is the other version, the outcome is the same. That's what I'm going to submit. So on these facts, on this chronology, the outcome is going to be the same. There was no bias. But I'm not running away from the point. I want to address it because I accept that the court needs to understand it, and I accept that it may affect whether you are at large to depart from the Part A. So for purposes of that, I have, because we hadn't anticipated that this would be an issue, I have reproduced the heads that we filed in the Part A court, only the 6 or 7 pages dealing with bias. Could I beg leave to hand them up? It's literally a cut and paste.
You may do so.
Thank you. Sorry, I don't think Maria's got. So what you will see, Justice Nuku, members of the bench, I've included the cover page and scrawled on that these are Part A. I apologize for the handwriting. Then I've included the table of contents just so you can see them in context. And then I've just included the relevant pages. If you want the rest, we can provide them, but you have enough paper. You do not need more. Yes.
We don't need the rest.
Yes. So you will see that at paragraph 78 through to 101, we addressed last time the question of the test and the conflict of interest. I'm not going to read this to you. I'm sure the court will read it in its own time. But I would like you to turn to page 29, paragraph 82, because I can't remember whether it was Justice Francis or Justice Nuku put the question to my learned friend, Ms. Pillay, has anyone applied the double reasonableness standard of judges to the President? And the answer is yes. The answer is that is the way that the state capture full bench did so in dealing with the President Zuma's review of the state of capture report. And we've explained this in paragraph 82. So there, of course, the issue in state capture was whether the President was biased and therefore couldn't appoint a judge to head the state capture investigation. Advocate Madonsela had said that he was, and therefore that it was appropriate that the Chief Justice pick the judge. President Zuma reviewed and challenged that, and said that there was a problem. And what the public protector in that case had said was that the president had to be removed, I'm reading from paragraph 83, in order to exclude any perception of bias and to protect the integrity of the commission in the eyes of the public. And then the State Capture Court went on to apply the principles of recusal that apply to judges. Those principles, we say, require recusal only when there is a reasonable apprehension of bias in the minds of a reasonable litigant in possession of all the relevant facts, that a judicial officer might not bring an impartial and unprejudiced mind to bear on the resolution of the dispute before the court. This test comes from a presumption of impartiality and a double requirement of reasonableness. And over the page, without other evidence, judicial officers are assumed to be impartial. This flows from the nature of their office and from the oath that they take. In addition, both the person who apprehends the bias and the apprehension must itself be reasonable. And if I can just read from that judgment, what the court said at paragraph 146, and this court will find this at page 192 of the bundle of authorities for the respondents. The full bench said there is no reason why the recusal principle should not apply to the president. And then the principle of recusal applies here because the president has an official duty to select a judge. So after summarizing the double reasonableness requirement and referring to SAFU, which is where it had been embraced by the Concourt, the court said there's no reason why it should not apply here. So the court applied the double reasonableness requirement. Now, our submission is that the court was right to do so. Let me just explain why. We make the submission at paragraph 85. The position of the president and that of a judge are not identical. We accept that. But the president does take an oath. He takes an oath to promote all that will advance the republic and to discharge my duties with all the strength and talents to the best of my knowledge and ability, and true to the dictates of my conscience, and to do justice to all. And we say that courts would not lightly assume that the president would violate his oath, particularly where it's something where the Constitution confers a power directly on the president. Now, we are not saying that the double requirement of reasonableness applies to every person who is deciding a tender, to every person who is awarding a dog license, to every person who's awarding a passport. Those people do not take oaths. Those people are not singled out by the Constitution, and they're not the head of state. We say that there is good reason to apply it here. But can I put it at its lowest? This court cannot find that the full bench in Part A was clearly wrong when the full bench in state capture took the same approach. You'd have to effectively find that that court was clearly wrong too. Now I must say, in fairness, that point is not argued in detail in that judgment. It's simply, but the finding is clear. 145 applies the SAFU double unreasonableness. 146 says this applies to the president. So we say, yes, we understand that the president is not the judge and that you could reach a different conclusion, but we said you can't say that it's clearly wrong.
So if I understand the argument,
yes,
every official that takes an oath this double test would apply, double reasonable test.
I wouldn't go that far. It would have to be an official. The president is the highest being in our country in the constitutional setting. You might well take the view, Justice Francis, to say it applies to the president, perhaps the public protector, perhaps the head of the IEC, perhaps even cabinet ministers, maybe the premiers. But the oath is there's no magic in the oath. The oath is just one of the ingredients. But so we submit that it is right, and we argued that it's right, and if the full bench went astray, they were led astray by me, which is the reason that I wanted to make the argument. But I'm going to say to you in a moment, Justice Francis, that even if they're wrong, they were not clearly wrong. But even if they were clearly wrong, it makes no difference in the end, because then you are left with the ordinary standard, and the ordinary standard is a reasonable apprehension of bias. And that's why one must be careful. I know, and I say this with great respect, I know judges love the double requirement of reasonableness because it speaks to the sanctity of the judicial office. But is there a fundamental practical difference between saying the apprehension of bias must be one that is reasonably held by a reasonable person and saying that there must be a reasonable apprehension of bias? I accept there's a difference, but the difference is sometimes a little thin one. In the present case, if you just apply the standard reasonable apprehension of bias, which is what Pudger says, which is what every jockey club case for the last 100 years has said, we're not there. And so this court could quite comfortably duck the issue by saying, we think that the full bench may have got it wrong, but we're bound by it. It's consistent with state capture, but in any event, it makes no difference, because on the facts of this case, there is no bias on either test, and that would leave it open.
You see, because, I think a judge is a different animal from an official functionary, and I use the term functionary advisedly.
Yeah.
Because the judge is trained, they constitutionally presumed to be independent.
Yes.
So the attributes of a judge are very different from what. So they.
Justice Francis, you will not hear a word of disagreement from me. If I compare the person who I have to go and deal with at Home Affairs to apply for my son's passport, who's making a decision that's going to affect whether we can go on holiday, and you're saying, and he takes a dislike to me and therefore refuses, I think establishing bias in respect of him is going to be pretty easy, whereas establishing bias in respect of a judge is a very high threshold for all of the reasons you give. The question is only this: when we look at the president, who is not just some person behind a counter, some functionary, he is the highest constitutional being who takes an oath, and we vest all sorts of constitutional powers in. Where does he fall? My submission is he falls on the judge's side, but I accept that you could reasonably conclude the opposite. My only point for present purposes is it actually doesn't make any difference. Because even that low-level clerk, and I mean no disrespect, who refuses me a passport for my son, the test is, was there a reasonable apprehension of bias? There's still a requirement of reasonableness. It's always going to be a requirement of reasonableness. It's just single reasonableness versus double unreasonableness. And in the present case, it really makes no difference, as I'm about to explain. So the other case we draw attention to, just for the sake of completeness, at paragraph 87, is the Corruption Watch case. And the Corruption Watch case was the case about the NDPP, and it was about whether President Zuma could appoint a new NDPP, having effectively dismissed, or not dismissed, having agreed with Advocate Nkasana that he would leave office. And there the court made reference to section 96(2)(b, and although it didn't expressly refer to the standard of judicial recusal, its judgment is perfectly consistent with it. But it doesn't answer the question, let me say. It doesn't. I can't suggest it answers this question directly. I'm simply drawing it to your attention for the sake of completeness. It is the only other judgment we can find which deals with the question of bias on behalf of the president. And it doesn't really take it in either direction. But against that backdrop, can I explain to you why it doesn't matter by dealing with the different categories of bias that are alleged? The first is the timing. I've already explained why the timing doesn't go anywhere. The second is the litigation. Now, again, this is where I got that sinking feeling yesterday when Advocate Mpofu, our learned friend, said, well, the president made an undertaking not to do this if there was pending litigation, and now go and have a look at the unsealing litigation. It's still pending. That's it. And you may recall I asked him for a reference to the papers because I was trying to figure out what I'd missed. But the only reference that I was given to the papers was, I think, the cover sheet of an order which reflected that the president was listed. But when you go and look at the true facts on these papers, that submission is patently bad. And I know my learned friend has taken you there, but it's so bad that I must just repeat it for a moment. If I could just ask you, I'll read it to you. But the first reference is the answering affidavit of the president. It's Bundle A, Volume 4, page 335 to 37, paragraphs 35 to 39. Now, that is where the president deals with the unsealing litigation. And the reason I was so concerned about how I'd missed it is I'm in that case for Amabungani, and I couldn't understand what I'd missed. But when you go and read the facts, it's absolutely clear. The president says, I assume you're talking about the unsealing litigation. It refers to the matter in which the EFF sought the unsealing of certain documents which had been filed in the review process, which had been sealed because the Financial Intelligence Center, that's the FIC body under FICA, they had asked for them to be sealed. They had asked for them to be sealed, the FIC. The public protector was cited as a third respondent in the EFF litigation, but did not participate. So the public protector is not the applicant in that case. The public protector is not even participating in that case. It's just a named party. Then the President says, in my official capacity, I had no interest in the EFF litigation. My interest was as a member of the ANC, which was part of the CR17 campaign. Once the CR17 campaign intervened, because what happened was the trustees of the CR17 campaign intervened as respondents. Once they applied to intervene, I took a back seat and allowed the CR17 campaign to take the lead in the litigation. This is clear from my short confirmatory and explanatory affidavit. Then the point is made that the EFF lost, which they did, and that they haven't progressed it. There's still a leave to appeal pending. And then the point is made at 38.4, in any event, the Constitutional Court has spoken the final word on the Public Protector's jurisdiction in relation to CR17, and this issue is not revisited. So I mean, even if the EFF unsealed it, that doesn't undo the Concourt's judgment in the CR17 matter. That judgment is binding. It's been set aside, the report. And so then the President concludes, for all of these reasons, I must respectfully say that the Public Protector's reliance on the EFF litigation must fail. In that litigation, neither she nor I are active participants, and the litigation has no bearing whatsoever on A, the Public Protector's powers in respect to the President, B, my powers in respect to the Public Protector, or C, any other issue that could found a conflict of interest. I mean, it's pretty firm. You would then expect a robust reply, given what was made of it yesterday. When you go to the reply, you will find that in Bundle A, Volume 10, 971, paragraph 71. Here is the totality of the reply to those paragraphs I have just read you. I'm advised that it will be demonstrated during legal argument that there's an undeniable relationship between the Bosasa CR17 matter and the sealed document matter. That's it. That is the litigation which you heard yesterday in argument produced the conflict of interest. With respect, the argument does not get out of the starting blocks. So what are we left with? We are now left with the last leg of the conflict, which is the investigations, the pending investigations. And what you are told is you are told that because there is a pending investigation, there is inevitably a conflict. That is the argument that was advanced last time, and was rejected. That is the argument that is advanced this time. Now, I'm not going to take you to the details of the investigations. That's not my job. I don't even have the details. But my learned friend, Ms. Pillay, has done so. Lord, I see it is almost 1:30.
Yes, I was thinking that if you are going to be starting with a new topic,
Yes.
perhaps it's better you start with it once a day.
I would much appreciate that if it couldn't. Thank you.
All right, court will adjourn until 2 o'clock.
Okay, I'll go to the front in my volume 12.
Shall we move to the back bench? Yeah, we're going to give you guys upgrade. We're going to give you an upgrade to business class. Yeah, we're moving for you guys.
Okay. No, you can do that. You know what? Oh yes, so that we don't have to do it during the lunch.
Exactly.
I mean, in session. Yeah.
Yes.
Okay.
Yeah.
Can we? Okay then. No, because.
Yeah, you guys can come around from that side because Steven and his team are here.
Taken. Yeah.
Ushilo sosobala wathi
Court, I am, through the bulk of my submissions, I have dealt with the whether the proceedings have started. I've dealt with the timing point. I've dealt with a large part of the bias point, but I must now deal with the investigations. And then I just need to deal briefly with the contempt contract point and costs. But if I could return to where I was. So I have dealt with the question of the test to be applied. And I've made the submission that the full bench, at the very least, was not clearly wrong in applying the double reasonableness requirement, because that was the approach that was taken in state capture by the North Gauteng full bench. But I've also submitted to you that if it was clearly wrong, for the sake of argument, it makes no practical difference, because the only debate we're having is whether it's a double requirement of reasonableness or a single requirement of reasonableness. Reasonableness always qualifies bias, even all the way down to the Home Affairs clerk, which I spoke about. I then dealt with the timing and the question of the unsealing litigation, and I was about to commence with dealing with the investigations. Now, my learned friend Ms. Pillay has dealt with the facts of the investigations. I wish to deal with the principle, if I may. And I wish to deal with the principle on the basis of the heads from Part A, which I handed to you during my address. And if I could ask the court to begin at paragraph 90. Because the submission that we make are that the mere existence of a pending complaint against the president, or any president, because we're making this at the level of principle, the mere existence of a pending complaint against the president before the public protector or the head of the Electoral Commission or the Auditor General is not a basis to find that the president is conflicted or biased by itself. There might be special circumstances, and I'll come in a moment to why there's been no showing of those here, but there might be special circumstances which justify it, but the mere existence of a pending complaint, even a significant one, is not enough. And what we do in the heads as follows, is we set out a series of principled reasons which have nothing to do with the facts of this case, but explain the principle. And we give 9 factors. I'm not going to read them all to you. I'm going to focus on 6 of them, if I may. The first one we make is at paragraph 91, which is that the constitutional role of the public protector is to investigate the executive branch. That is what whoever the public protector does. So there's a very high likelihood at any time that a potential suspension comes before the president, or indeed the deputy president, that there will be a pending investigation. That just stands to reason. At any one time, the odds of a pending investigation are quite high. But the Constitution still granted the power to suspend the PP to the president. So the constitutional drafters made a decision to give that power to the president, and we submit that that is a clear indication that the Constitution does not anticipate that merely because there is a complaint, that is in and of itself enough to disqualify the president from making the decision. And we've also made the point that it's important that we're dealing with suspension here. We're not dealing with dismissal. We're just dealing with suspension, and the Constitutional Court has held repeatedly that there's nothing wrong with affording a member of the executive the power to suspend someone who might investigate them or their associates, as long as there are adequate safeguards. Can't be without pay, it can't be for an indefinite duration, etc. And we say that that's important. So that's the first point. The second point is that although it is the president who decides...
So it's at the level of who might that we are dealing with, though that the Constitutional Court dealt with. There.
Exactly.
Okay.
Exactly right. Exactly. Yeah, I'm not saying that the court dealt with this factual situation.
So as a statement of general principle, it seems nothing wrong to confer powers on a person,
on a member of the executive.
On a member of the executive, yeah, exactly. I think that makes
exactly. The second principal point we make, Justice Nuku, members of the bench, is that although the president has the power to decide whether to suspend the public protector, he cannot exercise that power on a whim. He can't wake up one day and decide to suspend the public protector. He can only even start to exercise his power after the National Assembly commences proceedings to remove the public protector. That's the whole reason we had that debate, Justice Lekuleni, about the start of the proceedings. And so what that means is that when the president decides whether to suspend the public protector, there will already be credible allegations of misconduct against that person. and the same for the head of the Electoral Commission or the Auditor General and so on. So it's not something that the President can easily abuse or use to get rid of a troublesome public protector. He only even gets to have a debate about it once the National Assembly has decided to institute the proceedings. And let me say that the reason I'm making these points is when you read cases like Glenister, McBride, Van Rooyen, they all say you don't just focus on the individual decision, you focus on the safeguards to understand whether there is any difficulty, any conflict of interest, and so on. The third point we make is that the public protector's power, so we've spoken about the powers of the President. Now let's speak about the powers of the public protector. The public protector has limited powers. She has no power to directly discipline the President. She can't remove him. She can't suspend him. That power is reserved exclusively for the National Assembly. She also cannot criminally prosecute him or even require that he be prosecuted, because you will know that one of the issues that emerged in the CR17 case was that the public protector had directed that the NPA engage in certain prosecutions, and the Court said that's unlawful. So the public protector can't require that he be criminally prosecuted. She cannot prosecute him. That's reserved for the National Prosecuting Authority. So all she can do is make findings and require him to take steps to address the consequences of any unlawful action. Now, why does that matter? It matters because we accept that those findings are significant, but it reduces the extent of the conflict. Because if the public protector could make a decision that the President is to be removed, well, then the conflict, I can understand, would be heightened. But the public protector has no power to do that. She has very limited powers. Not very limited, that's overstating it. She has limited powers. She can only make a finding and make recommendations, and ultimately it's for the NA to decide whether the President stays in office, and it's for the NPA to decide to prosecute. But more importantly...
Sorry, Mr.
Yes, of course.
It might be a good point to make as a general proposition.
Yes.
But the decisions of the public protector
yes.
may have serious consequences, as we know from history what has happened.
I absolutely
so
accept
it's
that.
not merely the fact that she may not be able to take remedial action of the sort that might involve the removal, but it's the findings that's made that might be, have a consequence.
Justice Francis, I accept that unreservedly. That's why I caught myself when I said she has very limited powers, because that's to overstate it. The only point I'm making, and the reason I'm making it is I'll come back in a moment to the contrast between this case and the Corruption Watch case about the prosecutions, where in that case what was at issue was hand-picking someone who would decide whether President Zuma got prosecuted. And my only point is that this case is not the same as that case. But I accept that it can have consequences. I unreservedly accept that. But perhaps, Justice Francis, just to ally to the point, it's also true that the exoneration by the public protector. So we've spoken about the fact that an adverse finding by the public protector doesn't remove the President, but conversely, an exoneration by the public protector doesn't fix the President's problems. Because if some public protector wrongly whitewashes a President accused of money laundering or accused of corruption, of course it remains open to people to approach the courts. It remains open to the National Assembly to make its own determination. It remains open to the NPA to prosecute. She doesn't preclude any of them from doing so. So whichever way she goes is not determinative. That's the only point I make. The fourth point, and this really is fundamental, is that if the President suspends the public protector, it does not end or even delay an investigation. If we were in a world where the suspension of the public protector meant there was no one to carry on the investigation, I accept there would be a different world. You may recall that there was a problem in Parliament at one point, that there was a problem about the Inspector General of Intelligence, and his or her term had come to an end, and Parliament couldn't get it together to appoint a new one, which meant there was no Inspector General of Intelligence. That is not the case here, because the Act makes clear that the Deputy Public Protector steps into the shoes of the Public Protector. That Deputy Public Protector is not appointed on an ad hoc basis. The Deputy Public Protector is selected by the National Assembly in advance of this and will step into the shoes of the Public Protector and carry on. So at the level of principle, and I'll come back to the facts in a moment, but at the level of principle, there's nothing that says that suspending a Public Protector is a way of stopping the investigation. Now, I'll come back in a moment to whether there's any showing that advocate Galeka, the deputy, is biased, because that again might be a relevant fact. But just let me leave that. I'm just dealing with principles, just for a moment. The fifth point we make, if you would turn the page, I'm now dealing with the 7th of the 9th, because I am trying to curtail it. We persist in all of it, but I'm trying to focus on the critical ones. We say 7th, if the mere existence of a complaint could prevent the president from acting, it would obviously be open to abuse. Any member of the public, or the public protector herself, could prevent the president from acting by initiating a complaint. So, one never knows why people lodge complaints and why they lodge at the time. We know the public protector has the power to self-initiate. So if the mere existence of a complaint produced a conflict, it would open the door to the public protector effectively avoiding accountability. And then lastly, we say that the case is obviously distinguishable from 2 prior cases, that's State Capture and Corruption Watch. But before I get there, I'd like to deal with the facts. And then I will turn to these last cases. And can I draw attention to the following facts in the present case? First, and perhaps fundamentally, there is no suggestion, nothing, not a word, that the Deputy Public Protector is in any way biased towards the President, a lackey of the President, somehow inappropriately linked to the President, not one word. Now, I immediately accept that if one could build a case which said the Deputy Public Protector is the President's friend, or the Deputy Public Protector has shown her bias, or anything like that, then you could say, well, now the President is just picking and choosing someone who is warm towards him. But there's not one word. So the Deputy Public Protector, in accordance with the law, must be presumed to have been properly appointed, must be presumed to do her job properly, and there is simply no basis for saying that you can assume that the Deputy Public Protector will not. Just as if I applied for the recusal of a judge, you can't say I'm doing so just because I know that Judge X is next in line and I like him. There's just no basis for saying that unless there is something to say that it's forum shopping. So this suggestion of forum shopping is without merit. The second point that I would make is that this is a complaint, pala pala I'm now dealing with. It is a complaint that post-dates the President's call for the Public Protector to make submissions on whether she should be suspended. Now, what do I mean by that? You will recall that the President made that request on the 17th of March 2022. You will recall that the President received the submissions on the 26th of May 2022, and you will recall that Mr. Arthur Fraser raised the pala pala question on the 1st of June. So this is not a case where the President is being investigated about something and decides quickly, I better suspend the Public Protector, let me initiate suspension proceedings. It's not that case. The President initiated this process more than 3 months before pala pala was anywhere near the public domain, before there was any complaint or anything else. And so to see it in that way, as being retaliatory or a conflict, is very difficult. The third point.
Now, when you say conflict, are you saying conflict as contained in Section 96?
I am, and let me just explain why. The submission I'm making, Justice Nuku, is this. The first question to ask is, does the mere existence of a complaint against the President produce a conflict a la Section 96?
No, it depends on the nature of the complaint, of course. If it's going to...
Well, I'm pleased with respect that you say that, but that was not the case advanced here. The case advanced by the Public Protector is that the mere existence of pending complaints does it. So let me, if I can get that first question out of the way. Does the mere existence of a complaint produce a conflict for 96?
And now it just comes, if we are focused on Section 96, I think it's clear that it's not.
Well,
it's not,
well, with respect, you and I are in agreement. But then the question is, if you accept that it's not the mere existence of a complaint, then the question is, what is it about the facts of this complaint that take it out of the ordinary and make it into a conflict? And that's what I'm dealing with here. And I'm accepting, for example, Justice Nuku, that if you could show that the Deputy Public Protector was a friend of the President's, then you could say...
I think your approach might not be quite correct, because this is a restraint on the exercise of public power, which
Yes.
says in these circumstances,
Yes.
you might not act. And what are these circumstances? These are circumstances that expose you
Yes.
to the risk of a conflict between your private interest and your official responsibilities. And your colleague, Ms. Pillay, has considered that in this matter, there is private interest. You can correct me if I'm wrong, Ms. Pillay. I don't want to misquote you. She is not in it.
No,
So there is, on one hand, an acceptance
Yes.
that the private interests are at stake here.
Yes.
And we must also accept that in exercising the power as conferred in Section 193, that is an exercise of that is the power that is conferred.
I absolutely accept that. But can I try and articulate the point? And I'm sorry, I haven't articulated it well. Let me try and articulate it better. Would you just assume, for purposes of argument for a moment, that the decision on whether the public protector should be suspended, I'm just speaking in principle, that the question of whether the public protector will be suspended will have no impact whatsoever on the way the complaint against a president proceeds? I'm just asking you to make the assumption for a moment. Assume that whether it is public protector A or deputy public protector B makes no difference whatsoever to how the complaint will proceed. Well, in that case, there is no conflict, because the president does not benefit from a suspension decision. The complaint is going to take its course. He's either going to be found to have breached the ethics code or not, etc. So if you assume that the decision he makes has no consequences for him, then there can be no conflict, because his private interest is not advanced by his decision and his private interest is not retarded by his position. So I'm making the submission to you that if you accept that assumption, and I'm just speaking about principle, that the decision will have no impact on whether he does well in front of the public protector or does badly, then there is no conflict, because the decision doesn't impact on his private interests.
But that talks to actual conflict.
Yes.
That's one thing.
Yes.
There is also the risk.
Yes. But there is no risk.
Or if you assume.
If you assume, I'm asking you to assume. I'm asking you to assume that what happens in the investigation will be unaffected by whether he decides to suspend or not. I've asked you to make that.
Yes.
Then there's no conflict. There's no risk of conflict, because his interests will not be promoted or retarded. Now let's look at the opposite. Let's assume that the public protector A is hostile to the president and public protector B is the president's best buddy. Deputy public protector is the president's best buddy. Then, of course, I accept that there would be a conflict, because the question of who's going to be investigating is going to have a direct effect on the odds of the president getting clean. So now I ask the question, on these papers, what showing is there? By inference, by speculation, by anything, what showing is there that the president is going to get a better deal or a better hearing in front of the deputy public protector than in front of the president?
And you see the examples that you make.
Yes.
Make the point that I think the applicants are making. You can have one instance where there is not going to be actual conflict, but you may have an instance where there is conflict, which means that the risk is there. Isn't that?
No, with respect, because the way it works, with respect, is that the power is vested in the president by the Constitution. And before you can say that the president is deprived of that, you need to show a real risk of consequential prejudice to him, a real risk that his decision is going to affect his interests. And I'm going to demonstrate that with reference to the state capture case. Can I go there? Because when you have a look at the heads, we deal with this in paragraph 100 and following. And the point that we make is that appointments are very different from suspensions. So let me just explain what I mean. In the state capture case, President Zuma was going to be able to pick a judge, any judge, from across the country, to investigate him. He could pick Judge Lekuleli, Judge Nuku, Judge Francis, Judge Zondo. He could choose anyone.
You could presume that the judges would be impartial.
You could, but the point is that the perception would be created that the president, and that was the point that the state capture judgment made, that the perception would be created that this is the hand-picked judge. In the corruption, can I just finish?
Okay.
In the corruption watch case, exactly the same problem, that the president could pick any person with an LLB to replace Mr. Nkasana, anyone he liked. There would be no safeguard from the NA, there would be no safeguard from the courts. He could pick anyone he liked. Now, in this case, it's exactly the opposite. In this case, the president's suspension of Advocate Mkhwebane doesn't give him a right to pick anyone. It gives him the right, not the right, it has the consequence of the Deputy Public Protector, who was selected by the National Assembly, how many years ago? 3 years ago, 4 years ago, before any of us were here, being elevated into the position. Now, Judge Francis, you were going to ask me a question, and I think I understand. To the member of the public, doesn't it look...
Well, let me ask.
I'm sorry, because I want to come to that. I'm so sorry.
Now, but just to follow up on your thinking, the president cannot halt the investigation. It has to continue.
Yes.
But what he would do by suspending Advocate Mkhwebane is that he takes her out.
Yeah.
A person who has been doggedly, rightly or wrongly, going after him, but we know at least that person's out of the picture. So anybody else will do.
Yeah.
Could that argument not be made? When it comes to perception,
I understand.
obviously it may not be in fact, and I not for a minute presume it to be in fact, but I'm just putting it to you that might be a perception.
Yes. Justice Francis, I'm very grateful for the question because it's the critical question, and let me deal with it. In the Constitutional Court judgment in Van Rooyen, which my junior is going to get me a reference now, the Constitutional Court dealt there in the context of judges, but dealt with the question of when there is a reasonable perception of bias or a lack of independence. And that applies here because, of course, it's about, there it was about judges, about the executive appointing and suspending magistrates. Here it's about the executive suspending the public protector. And the point that is made is that the reasonable, well-informed observer, the person we're asking for in the public, is the person who is in touch with our Constitution and its safeguards. So if you ask, when you ask me the question, Justice Francis, you cannot ask, not you, I cannot ask the question, does my 18-year-old son think it's a problem that the president suspended the person who would investigate? I've got to say, that reasonable person who is in touch with the Constitution and the safeguards it creates, and who is in touch with the safeguards for the powers, and who understands that if he suspends the public protector, the deputy will come in and everything will carry on. I have to ask that. And I have to, if you give me a moment, I'll read it to you.
So that you answer this, because I think it's related to this.
Yes.
I want to put also this proposition to you that you could ask the same questions in respect of the appointment of a judge, so that you answer them together.
Yes, yes. So what? I'll just give you the reference to start. It's S versus Van Rooyen, 2002, 5 SA 246. It's a decision of the Constitutional Court, and what had happened in that case was that the High Court, Justice Southwood, had struck down a series of provisions of the Magistrates Act on the grounds that they didn't comply with the constitutional guarantee of judicial independence. And on appeal, Justice Chaskelson, for a unanimous Constitutional Court, said that he had got it wrong. And he said at paragraph 32, from the objective standpoint of a reasonable and informed person, that's the standpoint. And then I'm just trying to find it, if you give me one moment. I'm using Mr. Bishop's laptop, and I really do not enjoy, hold on, let's see. Just look for informed. And what he said is you have to be informed. You have to take someone who's informed. Just let me find it for you.
Yes. Where am I pressing to do the next one? Here. Yes. Yes. In paragraph 34, he said the High Court adopted this test. I agree that an objective test, properly contextualized, an appropriate test. The perception that is relevant, and that's the point about perception, Justice Francis, the perception that is relevant, however, is a perception based on a balanced view of all the material information. As a United States court has said, we ask how things appear to the well-informed, thoughtful, and objective observer, rather than the hypersensitive, cynical, and suspicious person. And that's really the point. It is someone who is well-informed as to these issues, and is well-informed, and then that's at paragraph 34. And then it said the well-informed, thoughtful, and objective observer must be sensitive to the country's complex social realities, in touch with its evolving patterns of constitutional development, etc. But so the point I'm making with respect is, if you ask the question cold, should the Minister of Justice have the power, let's go back. If you ask the question cold, should the President have the power to pick a Chief Justice and to appoint judges to the Constitutional Court? A lot of people would say, no, that's a problem. He's going to be in that court the whole time. If you ask the question, should the President have the power to discipline magistrates? A lot of people would say, no, of course not. That's a problem. He's the Minister of Justice. But when you ask it in the way that the Constitutional Court requires it, which is it's got to be a reasonable, well-informed, thoughtful observers in touch with the safeguards and not the cynical, suspicious, hypersensitive person, my submission is that on the facts of this case, there is no showing of a conflict. And I accept Justice Nuku, Justice Francis, Justice Lekuleli, I accept that the case would be different if there was any allegation that the Deputy Public Protector was a buddy of the President, if there was any allegation that this suspensions process started only after this complaint lodged, if there was any allegation that the effect of this has put an end to the investigation into Pala Pala, but none of that is here. And so if you accept my first proposition, which is that the mere existence of a complaint is not enough to give rise to a conflict, and that's for the reasons I've articulated, then I submit that there are no facts before you to find that there is a conflict here. Because the only way you could do it would be to find that the mere existence of a complaint is enough. And for the reasons I've articulated, and as we've explained in these heads, that is not the case here. So our submission is twofold. Our submission is firstly at the level of principle. There is nothing about the mere existence of a conflict. I'm sorry. There is nothing that the mere existence of a pending complaint to the PP precludes the President from carrying out that function. That's the first point. And then the second point is, if you accept that proposition, what is there about the facts of this case that transform it and say that there is something? And I've given you examples of if the Deputy PP was not honest. I've given you examples if this suspension notice was initiated in response to Pala Pala, but there's nothing. And the only third point I would make is this.
Maybe before you move on that point, you make the point that because the investigation is going to continue in any event, so his suspension is not going to have an impact. But that holds true also in respect of the appointment of a judge who was going to do the state capture. But the investigation was going to continue, whoever was appointed, whether it was who was appointed by the President or not.
But I accept that, but there are two distinctions. The first distinction, Justice Nuku, the distinction between the state capture case is not that. The distinction in the state capture case is that it would have given the President a free hand to pick any judge he liked who would have been perceived as his chosen judge. Whereas in this case, that perception can't arise.
But the perception here would be he's getting rid.
No, but
I think that's the angle from which it comes.
But with respect,
but it's not about the appointment here, it's about
but with respect, the reasonable, thoughtful, well-informed observer would know that the impeachment proceedings were initiated in July 2021, would know that the suspension proceedings were initiated in March 2022, and that all of that happened, the call for submissions, that the submissions were lodged on the 25th of May 2022, and that all of that happened before Pala Pala had even arisen. The reasonable, thoughtful, and well-informed observer would know all of that, and would then say, this can't be a case of a president trying to get rid of a public protector. This is a case of a president responding to a process initiated by the NA and a process commanded by the Constitution. That's what the reasonable, well-informed observer would know.
But you go to the state capture, it was a continuation of an investigation that had started some time ago.
Yes.
So whoever was appointed was just going to carry on with what was being...
No, but with respect, it's different, because there, the president was given a power to appoint a judge because they'd been unable to get to the public protector had been unable to get to the bottom of state capture. And so the public protector said, this is a process which needs someone independent, and the president is given that power. To then allow the president, who was at the center of those allegations, so let me say it this way, the trigger for the need to appoint a judge to head up the State Capture Commission was the president's own alleged conduct, President Zuma's own alleged conduct.
Yeah.
To say in those circumstances, the very man who's at the center of these allegations must handpick the judge to investigate him from any judge in the country, that gave rise to an obvious problem. This is different. This is a suspension process which wasn't initiated because there's an investigation into the president. There's a suspension process that was initiated because the public protector is accused of having done things to the Reserve Bank in 2019. And it's a suspension process that was initiated because the National Assembly did all the start. So the distinctions are palpable in my submission. But moreover, Justice Nuku, let me take you at your question. If you have regard to the Corruption Watch case, and I think it was Judge Francis who put it to me, who said, well, you know, isn't it the same because nothing will end? In the Corruption Watch case, the president was hand-picking a NDPP who would ultimately have the power to determine whether or not he faced criminal prosecution. He would determine, that NDPP, whether President Zuma would be prosecuted. That is a far cry from saying here, where the president is merely suspending someone, and it's not going to have an effect, even if it went well or badly for him, it's not going to have an effect about whether it's prosecuted or not. It's merely a findings and investigation process.
But if to follow your argument, so it seems to be, you're suggesting that insofar as suspension of the public protector, the question of conflict does not arise because there is safeguard.
My submission is there is no conflict by virtue of the mere fact that there is a pending complaint against the president before the public protector. That mere fact does not create a conflict. That is my submission.
But if the complaint, if there is pending investigation that implicates private interest, that does not.
No, because always there are potential private interests. My point is slightly different.
Well, it's admittedly implicating private interest.
Let me put the submission clearly. The mere fact that there is a pending complaint which involves the private interests of the president is not enough to trigger the conflict.
Oh.
You have to go further, and you have to say there is something about these facts which takes it out of the ordinary, and there is something about these facts which produces the conflict, either because the Deputy Public Protector is a stooge, or because this was a suspension which was done purely as a retaliation because it was initiated after the complaint, or because there is some reason to think that this is going to be a whitewash. But in the present case, you've got none of that. In fact, what we know is that the President and the Deputy Public Protector are crossing swords, because the President asked for an extension, the Deputy Public Protector said no, and threatened to subpoena him. Now, I don't know who was right or wrong, and to be honest, for today's purposes, I don't really care. But the point is, that is not the idea of a public protector lapdog doing whatever the president wants. The actual way it's transpired makes clear that there is no cozy relationship between the two of them. If you could show a cozy relationship, that would take it out of the ordinary. Let me just say, one must be careful about saying that merely because there are some private interests, that is what takes it out of the ordinary. It doesn't with respect.
But that seems to be what that section talks about. It's the risk of the exposure.
Yes. That's what the section talks about. But my point, Justice Nuku, is there's nothing remarkable about a complaint to the public protector which implicates private interests of the president. That's what I'm saying. I accept that if there were no private interests, we're not even in 96. But let's take the examples of which we're aware. In Nkandla, that was a case about private interests.
Sometimes extreme examples don't help. There are gray areas that need to be seriously debated, and I think we are in that gray area.
Can I give you a more simple example? I'm representing the head of the RTMC, that's the Road Traffic Management Corporation. He is accused of having made improper, I mean, it's been set aside, but he was accused by the public protector of having made improper appointments because he didn't follow the PFMA. That's a classic public law issue. It's not about, he's not accused of corruption or anything of that sort. He is accused of having not followed the PFMA. Are his private interests involved there? Well, there's no suggestion of corruption, but if he was disciplined and if they were set aside, it might have consequences for him. So there are always private interests. Private interests apply whenever an official is alleged to have acted against the law, whenever that is the case. So my point is that the private interests magic.
No, I'm talking about the potential conflict that this section.
No, but the point I'm trying to make, Justice Nuku, is that whenever the president is accused of wrongdoing in front of the public protector,
Yes.
there is notionally a private consequence. There is notionally a loss of reputation, there is something else, whatever. The private interest doesn't do the work. You've got to look at the reasonableness of the perception of conflict. That's what does the work. It's the reasonable perception of conflict. And the reasonable perception of conflict is what arises from the state capture full bench judgment, the corruption watch full bench judgment, but viewed in the light of Van Rooyen. The question is there reasonably perceived to be a conflict of interest? And in circumstances where there's no showing whatsoever that this suspension would benefit the president, there's no showing whatsoever that this suspension was done in response to Pala Pala, apart from mere coincidence of timing, then there's nothing. And the third point I was going to make, Justice Nuku, you will recall that in my note, I had made the point at paragraph 98 that if the mere existence of a complaint, can I read in there, if the mere existence of a complaint involving private interest, just to be clear, if the mere existence of a complaint could prevent the president from acting, it would be open to abuse. Any member of the public or the public protector herself could prevent the president from acting by initiating a complaint, no matter its content. Now, Justice Nuku, I don't know why Arthur Fraser laid the complaint, and I don't know why Arthur Fraser laid the complaint on the 1st of June, just after that. I do not know why the ATM, who has been supporting the public protector, brought the complaint to the public protector on the 3rd of June, and I do not know any of that. My point is this. It demonstrates that if without more you can create a conflict merely because there is a complaint against the president which potentially impacts on his private interests, then you are effectively disabling the president, and you are in my submission, undermining the presidential powers.
Not when the Constitution itself makes provision for instances where the president can't act himself.
But the Constitution also says that it is the president who will suspend the public protector, even knowing that at any given time there will always be some or other complaint against the president. That's the point I'm making.
But it makes provision for instances where he can't personally act.
I understand.
In fact, in previous proceedings, he admitted that he would delegate the
Yes.
power to suspend.
And
so it's not as if there would be...
And with respect, do you know what would have happened if he delegated that power?
Now we mustn't go to speculation.
No, well, let me speculate. My speculation is then he would have been accused of bias in any event, because he was biased, and whoever he delegated it to, that delegation would have been challenged as being... and that's what everyone does, right? Is what you do... I've been an admin lawyer for a long time. When you complain about the decision maker, and the decision maker delegates to the next one, then you say, yeah, but you had no power to delegate because you were biased, and your delegation is fatally flawed, and therefore the whole thing goes out the window. So, with respect, it's one thing to say the president is involved in litigation against the public protector, and he's therefore biased, and there's therefore a conflict. That's what he said last time. It's completely another to say, merely because there is a pending complaint lodged 3 days after the submissions were due, that is enough to render a conflict. And that's my submission. It is simply not enough, absent some other facts, and there are no facts on the table in that regard.
So that's why we've spoken about the conflict of interest issue.
Yes.
And the test.
Yes.
Does the same test apply for bias then?
Yes. Okay. In my submission, because I'm very glad you raised that, Justice Francis, I don't think there's a different test in my submission. because one of the grounds for bias is personal interest. And in fact, in the Corruption Watch case, one of the things the court said is it said at paragraph 115 that given the involvement of President Zuma, it seems incongruous under those circumstances that President Zuma should then be seen to be appointing the NDPP, since his conflict, both actual and perceived, is self-evident. Judges decline routinely to sit in matters in which they are conflicted. But of course you know, and I know, that they do that because they are biased. I'm sorry, because they are perceived to be biased. So it seems to me there's one test. It's the reasonable perception of bias arising from conflict. And it's the same whether you view it under the reasonable perception test or under 96. I accept that it's the same test.
Because then the reasonable and informed person,
yes,
in relation to bias, must also be aware what guardrails there are in place,
exactly,
have some idea about the law,
exactly,
and have some idea about the facts and so on.
That's exactly the point with respect. The reason that 96 exists is for exactly the same reason that we have principles of recusal in a judicial setting. It's to make sure that people who are conflicted recuse themselves. And that Van Rooyen test in my submission applies directly to 96 when assessing whether there is a conflict of interest. It must be so, because otherwise, I mean, we all know, everybody's got theories about all countries in the world about people who are crooked, and this one's a conspiracy and that one's a conspiracy. That could never be the test for conflict. The test must be a conflict in the views of the reasonable, well-informed observer, a la paragraph 32 and 34 of Van Rooyen, who is aware of all the guardrails and who is aware of, can I give you a practical example? In Van Rooyen, the debate was it's impermissible to give the minister the power to initiate the removal of a magistrate from office. And Justice Southwood, with respect, I think had said, well, on that basis, there's a perception of bias, because there's a problem because the sword of Damocles would hang over the magistrate's head. But in the Concourt's judgment, it said, no, but the sword of Damocles can never drop because there is a safeguard, and the safeguard is the National Assembly or something. I can't remember the details. But what they said is, you've got to look at the safeguards, because it's the safeguards which determine it. And in this case, in my submission, when you look at the safeguards we've outlined, they are more than adequate, absent any special circumstances. And in the present case, there are no special circumstances in my submission, and therefore no conflict or bias has been shown.
But then, a well-informed observer, will you also not take into account the fact that when the President receives the one questions from the very same public protector suspend public protector, will you not take that into account?
He would, but he would also take into account that before Phala Phala even came into force, yes, the President had initiated the process, and the President had told the public protector to go and jump when the public protector wanted an indefinite undertaking not to carry it out. That letter that Ms. Pillay, my learned friend Ms. Pillay read, which said, I'm giving you no further undertakings. So that well-informed observer will of course look at all the facts, but there's no magic about those 31 questions, none whatsoever. And it would be different, Justice Lekuleni, if following the receipt of the 31 questions, the President proceeded to initiate proceedings to suspend the public protector, because then you could say, well, now we know what's going on. But in the present case, as the timeline shows, it's exactly the opposite. So my submission is there's no basis for that. Justice Nuku, I think I've outstayed my welcome. Could I briefly touch on the contempt and contract point, and then yes, a word on costs? On the contempt and contract point, we really have nothing to add apart from these 2 points. On the question of contempt, Justice Lekuleni asked our learned friend Ms. Pillay, well, isn't it a problem to take a decision in the face of a pending judgment? Justice Lekuleni, that used to be the law. There was a series of early 1900 cases which spoke about constructive contempt and said when you are making a decision which is at odds with a pending application for interim relief, you are engaged in constructive contempt. And those cases were endorsed by the SCA in the Gauteng Gambling Board case. And I used to rely on it all the time to try and persuade people not to take decisions. But in City of Tshwane, which we've cited in our heads, the Concourt said all of that is not good law, and that there is no reason to refrain from acting in a particular way absent a court order to that effect. That's what that Chief Justice Mkhwebane said for the unanimous court. It is in our heads. I'll just find the reference for you. You got it. It's sitting. I just wanted it in the heads because we've summarised the point.
You have it in your head.
It's in the heads. In any event, yes, it's we cited it at paragraph 112.1. Chief Justice Mkhwebane made it clear. I'm, with great respect, not sure the law should have developed in that direction, but that is the law, and it says so quite expressly. So there's no contempt.
So that's the last word on the matter.
Well, it is until the Concord changes its mind. And then the only other point to make is that on the question of contract, it's not clear whether our learned friend seeks to say that the contract, and I use the word in inverted commas, binds the President and is therefore enforceable. If so, there's no authority and there would be all sorts of problems about fettering by contract and all the rest. It seemed that, in fact, it was more an argument allied to the bias, etc. And for the reasons I've explained, there's no merit to that. But more importantly, let's take the high watermark. Let's take the high watermark which says that there was a binding contract. And the binding contract is, I will not suspend you until the High Court has pronounced on Part A. Well, then that contract was breached, but it was breached from late on the afternoon of Sunday 9 June until 10 o'clock in the morning on Monday 10 June, when the High Court delivered judgment and dismissed the application for interim relief. So it's of no consequence whatsoever. I once ran a labour case where I made a big speech about how someone had their contract breached, and it was politely pointed out to me by the arbitrator, yes, and they could have given 7 days notice, so would your client like 7 days salary? And that wasn't exactly what I was after, but that's all I got. It's exactly the same here. It's a breach without any consequence, because it was a contract which existed for the scope of less than 24 hours, and it made no difference, because it was dismissed and so be it. But there's no, let me say it. There's no showing of a contract. There's no showing that it's binding as a matter of law. There's no showing of procedural irrationality. But assuming all of that against me, there's just no way it could lead to a setting aside of this decision. Very lastly, Justice Nuku, members of the court, on the question of costs. We do seek costs against the public protector, and we seek costs on the following basis. The public protector is litigating, and that's the one thing that's become clear since yesterday. The public protector is litigating in her personal capacity, and we are a private litigant. And whatever you make of costs in respect of the National Assembly and the Speaker, my client is a private litigant, and my client is entitled to costs from the public protector, and she's entitled to costs against the public protector personally, and given all that's gone on, we would ask that that be made clear, that it's personal. That's the first point. The second point we would make is that we do submit that at least in respect of the persistence with the relief regarding the parliamentary proceedings, this application is abusive. We say the whole application is without merit, but we can at least accept that on the suspension point, the points are wrong but arguable. But I accept they're arguable. We would ask that the court direct that insofar as the costs concerned involve the parliamentary proceedings, that the costs be paid on an attorney-client scale. And so the order we seek is that the public protector is directed in her personal capacity to pay the costs of the Democratic Alliance, including the costs of 2 counsel, and that in respect of the parliamentary issues, those costs are to be paid on an attorney-client scale.
She's not raising a constitutional issue, sir.
She is, with respect, but there are 2 reasons that doesn't protect her. The first is that in respect of the constitutional issues, BioWatch only protects her if they're raised in good faith. In respect to the parliamentary proceedings, they are not raised in good faith for the reasons I've articulated. The second, Justice Lekuleni, is that the BioWatch principle does not protect private parties litigating against each other. It protects private parties litigating against organs of state. And in the present case, the public protector is a private body litigating against the DA. So we would say that she doesn't have a BioWatch shield for present purposes. And that is why, unless I'm getting it very wrong, in the Constitutional Court, the public protector was directed to pay the costs of the Democratic Alliance in respect of the unsuccessful appeal.
And the costs against the parliamentary respondents in Part B, they seem to be, I mean, I don't even know if it's 5 pages that has been spent in relation to that. Because remember, there was just that one line that says, I've got nothing new to add, and then there was also another sentence, a paragraph, and then another paragraph.
No,
it doesn't seem to be
Well, Justice Nuku, that is a matter for the taxing master.
Okay.
With respect, but at least as far as our heads are concerned, there are chunks of them that are relevant to that. But thankfully, you and I don't need to resolve that. It can be fought out in front of the taxing master, because really this court ought to send a signal that you can't litigate in front of 21 judges and then still come and try 3 more. That's my respectful submission. Thank you very much.
Thank you, Mr. Bartlender. Mr. Bofu?
Thank you very much, Justices. Good afternoon.
Good afternoon.
Thank you. As God pleases. Maybe I should start with the DA while it's still fresh in my mind. If you cut out the noise, the submission, particularly around the issue of conflict, is completely unintelligible because, and I'm starting with that point because it's quite central, but also it overlaps with the submissions of my learned friend Ms. Pillay on this issue. She at least quite correctly considered the private interest issue, as she must. But let me just point out that the private interest issue does not only relate to the Phala problem. The private interest issue relates to the Busasa matter. In fact, to all the conflict issues, maybe except one. And therefore, Mr. Bartlender's theory about this, that the suspension process was kick-started on the 17th of March and culminated on the 9th of June is correct. But actually, that submission assists us because it does not answer this question. Because let's assume for a minute that submission could get him out of the Phala crawl. But it cannot get him out of the very point that he's making, that it started on the 17th. If you realize that the privateness of the conflict affects the Busasa issue as well. Because on the 17th of March, already the Busasa investigation was already there. So it doesn't really help whether we use the 17th of March or we use if the only complaint we were bringing to this court was the Phala issue, then maybe what he's saying could have some merit. But right now,
Mr. Bartlender dealt more with the Phala issue on the basis that Ms. Pillay had dealt with the other issues that had been raised.
Yes, but you can't do that.
And in respect of the Busasa matter, the point that was made there was that there's no pending litigation between the public protector and the president, so there's no issue of private interest.
Yes. You see, that's exactly the problem. You can never look at these things in a compartmentalized fashion like that. Say, okay, now we're in the box of Busasa. Now we're in the box of this. Now we're in the box of this. We are talking about conflict which afflicts one person in respect of the suspension of another one person. And they interplay. That's exactly the point I'm trying to make. Once you do it like this and you do a box ticking, say, okay, now we're talking about pala. I'm making a principal point that the personal interest issue is central to all these conflicts. And nobody in their right mind can deny that the Busasa issue, in fact, justices, the entire defense of the president in the Busasa issue is that it's a private matter. That's the basis upon which the Constitutional Court found that the public protector does not have jurisdiction. Because they said, no, but this is a private matter. He was getting donations in his private capacity as an ANC person. What's your problem? So I'm merely making the point, and I don't want to belabor it much, that you, as you escape one trap, you get yourself into another, because there is a proliferation of these matters, and therefore the only defense that would work is one that gets you out of all of them. But this one doesn't. If it just gets you out of Pala, and then the one that got you out of Pala gets you into Busasa, and then when you're in Busasa say, no, forget about Pala, it's never going to work like that. You have to look at the system as a whole. So that's the one thing. The other issue, which let me just quickly get it out of the way because it's related to this, is that, and it's related to the point that you just made, Justice Nook. There does not need to be pending litigation between the public protector and the president. That's not the point we are making. The point we are making is that there is pending litigation which will have a huge impact on the question whether the president's conduct was subject to the jurisdiction of the public protector or not. In other words, what we are saying is that if the documents are unsealed, and you remember we've made this point, in fact it's in the president's own answering affidavit in these proceedings, where he says that let me just paraphrase. The public protector was found, and he says it correctly, was found by the Constitutional Court not to have sufficient evidence to sustain the idea that she might investigate Busasa. Now, if we accept that that is true, the only thing the public protector is saying is that there is now related litigation which might overcome that problem. So therefore, this idea that, oh, it's done just because the Constitutional Court has spoken is false. Why? Because, yes, on the facts of the matter as they stood before the Constitutional Court, that matter is closed. But it doesn't mean that if some whistleblower comes tomorrow and says, I have a photograph of the president taking money for CR17, then the public protector cannot act, just because there was some judgment on particular facts in 2021 or whatever. It doesn't work like that. And that's all she's saying. She's saying now there's a potential of new evidence which might make it, which might resuscitate the conflict. I think let me just put it in shorthand like that. And that cannot be denied on these facts. And this idea that my learned friend Ms. Pillay was putting here of trying to downplay the issue of the unsealing is not correct. I'll take your lordships to page 1079, which is volume 12 of bundle A.
You say 1079?
1079, that's correct.
That's
Volume
not
12.
12. No, my volume 12 starts at page 1101.
Okay, maybe starts at 1101, my lord.
That's volume 12
12.
or 14.
Oh yes, then yes, no, your lordship is quite correct. It's volume 11. Wow. That's actually why I couldn't find it from my. Volume 1079.
Maybe you can just read it for us.
Yes, it's volume 11. All right, and I did take you to it earlier, so I'll just re-emphasize the point. I took you to it in my argument in chief. Two quick points I wanted to make about this case. Yes, indeed, it's economic freedom fighters, but the first respondent is Matamela Cyril Ramaphosa. So here there's no doubt that we're dealing with personal issues. That's the point. But the mere fact that the public protector is cited as the third respondent, that's just, I mean, it's the same as the ATM and the UDM are cited as respondents here, but for all intents and purposes, they are on opposite sides to the other respondents. But the bigger point is the following. If you go to 1084, which is paragraph 8 of that judgment onwards, the heading there says the first respondent's argument. And it says, the first respondent, that is Mr. Ramaphosa, submitted that the CR17 campaign had ceased to exist after the election of the ANC National Executive and so on. Therefore, it was the National Assembly that elected him to serve as the President of the Republic, which led to his accession to CR17. I don't need to read all that. But the point I'm making is that his entire defense in that matter was that these were, it was the same defense for that matter as in the Busasa matter. So that's the connection between the two matters. In both matters, he raises exactly the same defense. So how can you say no? But it's stretching technicality to incredible levels to say no. But in the one case that deals with the same issues, the litigation is finished. But in the other case, which deals with the same issues, the litigation is continuing. But then exactly that's the point we're making.
So if I understood the argument in respect of the matter that concerned them as adversaries, the concession was made in the context of him saying that my suspension may have a direct impact in respect of the pending litigation.
Yes.
In the sense that it might take Advocate Mkhwebane out of it.
Yes, but that's
not the same exactly, because here they are both respondents. They're not adversaries.
Yeah.
I'm just raising it.
No, you're right. You're right. That's the argument. But I'm not. It's a valid question, Justice Nuku. I'm saying that's the argument, but I'm simply saying that argument is completely outrageous, because it's the issues. You can't do it at that level of technicality. The question is whether these issues, if they are brought back to life, will then bring back that adversarial conflict, so to speak. It's the potential. That's why we always talk about potential, the potential and the risk of conflict and all those things. We're not talking about at the level that, okay, now here you are the first respondent, now you are the third respondent. So what? The issue is more substantial. It is whether the dead, quote-unquote, issue in the Busasa matter is now, there's a risk of it being resuscitated by the currently pending litigation. Yes, because he's raising exactly the same defense in this matter as I've read out the first few, which he raised against the public protector in the Busasa matter. So the adversary nature is exactly the same. Now, anyway, I just wanted to get rid of that issue. But again, I would like to take you just to show that the DA's contribution here really is just one of more of a spoiler than anything, because there is, at least they've admitted that they're here because they are the complainant in the other processes. So they have a different type of conflict themselves. But this is what the DA says. This DA that has been standing here telling you that even bringing the heads from part A to say, what conflict? What are you talking about to us? This is what they say. If you go to page 500, and it's volume 6, there's a letter that starts at 501. Volume 6.
Volume 5 of which
6,
bundle?
volume 6, 501 of bundle A. No.
Yes.
Yeah, it starts at the letter starts at 501. This is a letter, just to paraphrase, which is written on the 16th of March, incidentally the day before the famous letter that kickstarted the suspension. It's basically the DA adding to the, the speaker's letter is on the 10th, suspend, in more subtle terms. But this one is suspend in more direct terms. But the important part, which I'd like to take the court to, is 507, where the DA talks about one of the 4 conflicts that we have cited. That is the Mervyn Dex conflict, if you remember, the one about the president saying that he knew that people were using public funds in the ANC to advance their campaigns. The DA, this is a letter from the DA's attorneys to the president. My client is aware that the public protector is currently considering a complaint against you laid by Mr. Mervyn Dex, MP. In his view, that complaint does not preclude you from suspending Advocate Mkhwebane. The case for a suspension is so overwhelming and the complaint will continue to be pursued by the Deputy Public Protector, who will act in Advocate Mkhwebane's position while she is suspended. But if it is your view that you are unable to act because of a potential conflict of interest, then you may ask the Deputy President to act in terms of Section 90, bracket 1B of the Constitution. But the pending complaint against you is no basis to avoid a decision on whether or not to suspend Advocate Mkhwebane. So this is the DA itself saying to the President, yes, we don't think that there's actual conflict, but rather than avoiding the suspension at all, we would rather you delegate the matter to the Deputy President because, obviously, because of the risk of the potential conflicts, all the things we've been talking about. It's them. Today, they come here, they say, what? What conflict are you talking about? They don't even concede to this conflict or potential or risk thereof that they themselves pointed out to the President. And that's the level of disingenuity we're dealing with in this matter. Now, and that touches on this other issue, which I must get out of the way very quickly. Justice Francis hit the nail on the head because if you remember the counter application that we filed on Sunday, in that counter application, when they said they're not going to give us the pala answers, we raise only one point. We say, oh, well, two. The first one is, no, we need the answers. Firstly, because we need to see if they really match the statements that have been made under oath, that you have complied fully with all the investigations and so on. I made that point yesterday. But we raised a second point there. We said we also would like to see these answers so that we know that they are satisfactory, so as to avoid our client's impression that this whole thing was about forum shopping. Now, the answer from the President was that they don't know what we're talking about. But that's exactly the point, and I've been making this point to my juniors at lunch, so I was very relieved. I should have made a bet when Justice Francis raised it. Forum shopping, as all lawyers know, you don't have to, and I think it was Justice Nuku who made this point as well. You don't have to know the person who's going to replace the one you don't want. And that's the point. On that point, that question from Justice Francis should close it. It works like this. We all know. I hope it is, okay, I won't mention names. In Joburg, there was in the early 90s, there was a judge who was the DJP, that might give some people a clue. If he was in motion court that week, everybody wanted to either postpone their matter or find someone else who can do it and so on for various reasons. Now, that's forum shopping. It means you just don't want Mkhwebane to do your pala investigation. Anyone else will do. So for this to be conduct that is inconsistent with the Constitution, you don't need a pliant deputy public protector. She might well be pliant or whatever, or I think the expression was that if she's buddy with the president. But that's irrelevant, because the improper motive is not so much the replacement, it's the removal of Mkhwebane from the scene, from perceived. That's really all there is to it. And every reasonable person who has been around South Africa will know that that is the risk of the conflict. And that conflict fits both what I call the common law conflict, which is the reasonable apprehension of bias on the part of Advocate Mkhwebane, because that's the test at that level. But it certainly fits the 96.2 test. So even if it may not fit and my learned friend, Mr. Badlander, mixes these things up, because he says, no, when he's asked questions about Section 96.2, no, it must be reasonable. There's no such thing about reasonableness in Section 96.2. It's not the common law conflict. it's a constitutional conflict, which is specifically designed by the Constitution for members of the executive. It's not the same, it must not be conflated with the common law conflict about double reasonableness and all those things. Those conflicts are the conflicts that belong to what I call the common law conflict, the bifurcated common law conflict that has as two legs, the actual conflict or reasonably perceived conflict. Section 96, you will not find such a thing in Section 92 as reasonable this or that. It's a simple matter. You may not act when there is a risk, put yourself in a situation where there's a risk of a conflict of interest between your public body duties and your private interests. Simple. Now, and then an inordinate amount of time was spent on trying to show that, as Mr. Badlander calls it, there's my volume 6. As Mr. Badlander calls it, that mere allegations and so on, or mere investigation, that's the line, both from the President and the DA, is not sufficient. But that's not our law. Our law is summarized in the binding case of the so-called EFF Nkandla case. Which we cite in our Part A heads, and I think there was a problem with the numbering, and so I'll just deal with it at the level of the paragraph 92 of the Part A heads. Thank you, my Lord. The test is very simple. It's not what Mr. Badlander is telling this court. The test is here. Chief Justice Mkhwebane said, her investigative powers are not supposed to bow down to anybody, not even at the door of the highest chambers of raw state power. We can read there, that's the president, that's the highest door of state power. The predicament, though, is that, and here's the important part, mere allegations and investigations of improper conduct against all, especially powerful public office bearers, are generally bound to attract a very unfriendly response. That's called, in other words, retaliation. That's all our case is. That the lowest test is put here by the highest court in the land. Mere allegations and investigations of improper conduct against all, especially powerful public office bearers, are generally bound to attract a very unfriendly response. That's what has happened in this case. There was a very unfriendly response, to be polite, in the form of a premature and illegal suspension. That's the real test, not this one that is manufactured here. And then it says, an unfavorable finding of unethical, corrupt conduct coupled with remedial action will probably be strongly resisted in an attempt to repair or soften the inescapable reputational damage. It is unlikely that unpleasant findings and a biting remedial action would be readily welcomed by those investigated. But yeah, I just wanted to get those out of the way. Now I'll go to where I was going to start with this reply. The first, as I did previously, I will start with some general remarks just to situate what it is that we are dealing with. Oh, yes. This is the other one. I'm sure the court, because these are topical matters, we will rely on the court being able to take judicial notice of some of the issues that are in the public domain. The DA, which is now saying what's wrong with this whole Pala thing, has famously referred the Pala investigation to the FBI on the basis that A, there's a conflict, B, there's there's an impeachable offense that has been committed, and all sorts of things like that. Now,
Malota, I'm sorry to interrupt. I have no difficulty with my learned friend trying to get evidence from the bar, but then I must be entitled to respond. Or are we just going none of this is on the papers. And my learned friend must decide whether he is seeking to tender the evidence from the bar, and if so, will I be given an opportunity to answer. But I can't allow it to go in uninterrupted when it's plainly not proper for it to do so.
All right. No, that's fine. I think I will withdraw that, just for the sake of progress. The point I simply wish to make, I don't want to belabor the issue of judicial notice. Everyone knows that these issues are in the public domain, but I don't want to go there. All I'm saying is that I suppose the letter that they wrote just about the Mervyn Dix issue is sufficient to demonstrate the kind of hypocrisy that we allude to. So if to put more examples is not going to make it better or worse. Now, the issue I really wanted to start with was a simple issue that I had pointed out in chief about the declaratory versus interdictory relief, because it's clear that there's still a problem of understanding that distinction. And that was made clear particularly in the address by my learned friend Ms. Pillay, when she made allusions to the exercise of public power, courts must be cautious, and that kind of thing. Things that belong to interdicts, and specifically interim interdicts. And I think Mr. Badlander, or all my learned friends, have also made a meal about the fact that the proceedings started about 2 weeks ago, according to them. The inquiry, the 194.1 process. Now, that is neither here nor there. We're here for declaratory relief. If we were here for interdictory relief, yes, you cannot, we all know, it's base one. You cannot interdict something that has already started. But that's not what we're here for. We're here for declaratory. So what does it matter if the Section 194.1 inquiry started last week or 100 years ago? It doesn't matter. We can come to court to be unconstitutional. And as I pointed out on the first day, that would then render it unconstitutional ab initio from the 8th of May, 1996. That's exactly the whole point. My learned friends miss the basics on these issues, because you are now told, for example, oh no, this is really a serious submission that is made, that stare decisis prevents this court from considering certain issues around the conflict, for example, because they were resolved. Right? At the same time, when it's pointed out to them, I think it was Justice Likuleni, that but there are other matters that followed after the grant of that judgment, such as Pala and so on. So how could this court, assume stare decisis applied, how could this court be bound by something that didn't even that had not even happened at that time, which is under appeal at the moment? And so the issue is quite simple. The whole point, and that point, by the way, is also made about this point about the removal committee. To say no, they came in Part A and they only raised the aspect of the alternative argument about the start of the proceedings, you know, the terms of reference, evidence leaders, and what have you. But so what? That's the whole point of the two-step litigation process, is that typically Part A is brought on an urgent basis, and you know, you put papers together and you go to court and say, you know, somebody's about to die. So pending the proper determination of the issues, please give us relief. But I've never heard of a situation that then prevents you, once you get or fail to get that interim relief, to reflect. That's exactly the whole point of taking, otherwise you just take a one-step process. It's because you are saying, I don't have time now to be going to law libraries and coming up with a philosophical treatise. I just want my interim relief. After that, I will then sit down, look at the case, reconsider, bring new points, and so on and so on. That's what we all do. But now we were told, no. This removal point, rather removal committee point, or the fact that the proceedings have not started, should not have been augmented in the normal way. And that's just, it's unheard of. The whole point about that issue is very simple, my lords. It is, at least Ms. Pillay tried. She says it was poorly pleaded. That was, I think, as high as she could take it, because she couldn't say it's not pleaded. Well, I'll take that on the chin. So, I'm a poor pleader. But that's not the point. The point is that the matter is raised, and you cannot say that the matter must be raised in a particular Queen's language that you prefer. The question is whether the matter has been raised on the papers, and the matter has been raised. But let's assume that I was an unrepentant poor pleader. At least that one I'll plead not guilty of, because I saw the error of my ways. Yes. And this is what we said, and I'll take you to paragraph 100 of our heads in this matter.
Part B heads.
Part B heads, my lord. Okay. I think this was also alluded to in the reply, but I won't put my head on the block. But on the heads, at least this is what we say, my lord. Paragraph 100. So it is our respectful submission, just in case somebody has missed this point. And remember, we do our heads first, so they do their heads a week later. So assume that it was poorly pleaded, then this is what we say here. It is also our respectful submission that the current process has not yet reached the stage of removal proceedings. but it is busy with the institutional predetermination of the existence of the grounds. Now, just in case I get accused of that flowery language, no, that expression I borrowed from the EFF impeachment judgment. I think it's paragraph 178 or 179, where chapter J says, there must be an institutional predetermination of the guilt or otherwise. And that's where that comes from. And we're saying that's all this is. You know, I'm sorry, no, let me finish this point because I might not come back. Then we say the respondents have failed to respond to the argument, which is where we still are. More pertinently, raised in the supplementary affidavit, that the present committee inquiry cannot properly be termed removal proceedings. And I underline removal, or one of my learned juniors probably underlined it for me. They cannot be termed removal proceedings because, strictly speaking, and upon a proper reading of the rules, its role is confined to determining one way or the other the issue of culpability or ascertaining the veracity of the existence of the alleged grounds for removal in terms of Rule 121 AD. It is only if, and then we underline the if that as well. It is only if and when culpability has been established in an inquiry that the committee can proceed to deal with the removal proceedings. And then, oh yes, there it is referenced. Then we say EFF impeachment, paragraphs 178 to 206, and then EFF speaker, oh yes. And then we say, in assessing this argument, regard must be had to the fact that there was a 23-year gap between the adoption of the Constitution, 1996, and the rules in 2019. The two instruments may not be perfectly aligned as yet. What does that mean? Partly it means what my learned friends ironically have said as well, which is an answer to a question that was put to me by one of the justices, I can't remember yesterday. I think it was Justice Nook, to say, yeah, but there's only one committee. And I explained this thing about the 23 years and so on. But the real point is more beautifully put by them, which is that at a legal level, you cannot interpret the Constitution by using the rules. You're not allowed to do that. You must interpret the rules by using the Constitution. So you can't say, when the Constitution says there must be a removal committee on its reading, say, no, it can't be, because some rules that came 20 years later do not provide for such a thing. What is that? Because that is exactly what you're not allowed to do, to use the rules to interpret the Constitution. So that's the point we're making there. But here's the real punch. We say the distinction between the two stages, in other words, the removal committee and the institutional predetermination, which is the 194.1 committee, was authoritatively defined beyond doubt by Jafta J in the so-called EFF impeachment case as follows, quote, for the impeachment process to commence, in other words, the removal committee, for the removal, the impeachment, remember in that case they said impeachment and removal is synonymous. So you can read it like this. For the removal process to commence, the assembly must have determined that one of the listed grounds exists. And then we underline the word exist. In other words, there must be the institutional predetermination of a finding, just as in the same way as with the judges, of a finding that there is gross incompetence in the case of judges, or there's incompetence and misconduct in the case of office bearers, of heads of these institutions. Now, something which, again, I still have to think about it because it occurred to me this morning. The incongruency that we talk about, I think, comes from this. Because I don't know if Mr. Bartlett was in that matter. I was in the EFF impeachment matter, probably one of the most difficult arguments to make in these types of matters. And our case was simple. It was, you cannot impeach without the rules that give life to the constitutional section. And we won that case 7 judges to 4. The other judges who disagreed with us were used this argument, which was, I can't remember, I can't attribute it, but somebody said, I think it was Mr. Badlan, about a situation where, what if this thing is so obvious that there's no need for an inquiry? And they even said, in the Nkandla case, there's already a judgment that says that Section 96 was violated. So why do you need an inquiry? Justice Zondo gave a long judgment along those lines. Justice Mkhwebane gave a long judgment along those lines. But the majority found in our favor that no, you cannot do that. You need to have an institutional predetermination of the guilt in the same way that it is done with judges. And at that point, exactly at that point, then you can start talking about removal. Hence, the majority prevailed. And now, the thing that I say occurred to me, that one occurred to me many years ago. But the one that occurred to me this morning is the following. It seems to me that the incongruency, and if Parliament ever needs to actually establish a so-called removal committee, it would have to look into the regime that is followed in respect of judges. And I've taken the liberty to make copies, and I know that the Lordships will have access to this, but, and I'm not going to go through it. It's just copies of the JSC Act.
Thanks. Thank you.
That is where I think this whole incongruency thing started. What happened is that Parliament took the rules, actually not Parliament, the DA, took the, Mr. Steenhuisen, took the rules that were designed as a result of the EFF impeachment case, and just changed a few things like disallowing lawyers to talk in the inquiry. I always say it's common cause that those rules are 95% of the rules of the Section 89 committee. But no, that's not what Parliament should have done here. Parliament should have gone to the JSC Act and look at the regime of the impeachment of judges. Why? That is because of what we're here for about. The major difference between Section 89 on the one hand and Section 177 and 194 on the other is the fact that for an impeachment of the president, there's no suspension. There's no suspension provision. So the president is impeached without any suspension. So even that doesn't matter if the president can kill 1 million people. You just have to wait for the Parliament to do its job. And partly that's an answer to Justice Francis's question to me yesterday of saying, shouldn't this be done at the earliest possible opportunity? That example shows that the answer is no. Because if society or the Constitution can tolerate a president who has killed 1 million people without even the possibility of a suspension until properly impeached, then surely the issue about the earliest. But that's not the point I'm making. The point I'm making is this. The model surely should be 177. That's where you should borrow from. You shouldn't be borrowing from Section 89. Because that is the provision that has a mirror image of a suspension provision called Section 177(3) of the Constitution. Now, I don't want to go back to that debate we had yesterday about at what point you'll find that, oh no, I think I must do that because it might be misconstrued. If you go to section, I think it's 23. Well, firstly, the answer to your question, Justice Nuku, where you were talking about suspensions that may have happened at an earlier stage, lies in the fact that if you look at, I think it's section 17, yeah, section 17, just the heading, it says, inquiry into serious, non-impeachable complaints by its chairperson or members of the committee. So there's a whole section that just deals with non-impeachable offenses, which was the answer I gave you yesterday. But when it comes to impeachable offenses, you then have to go to chapter 3, which starts at section 21. Again, I won't go through this. The Lordships will go through it in your own time. I just want to point something out which might look like look a bit odd, but it's explained by what actually happens in practice. It says that when there is a suspicion of the offense having occurred, then the JSC, provided that the person is in charge of, or rather is involved in a process in terms of 177.1, may, among other things, advise the president to suspend. So at face value, that might look like what it's saying is that just as soon as there's a prima facie case, you may suspend, but no. As I explained yesterday, what actually happens is that the JSC, there has to be that finding, and then it goes to the JSC, as I said, quote unquote, sitting as the removal committee, and only at that stage. The real point I'm making is that it only happens once there's been a finding of gross misconduct in the case of charges. That's a non-difference, because here we know what we deal with misconduct. But the bigger point is to go back to paragraph 179 of the EFF impeachment case, because that makes it clear that there must be that institutional predetermination of the existence of the offense, and then you can start talking about impeachment committee or impeachment proceedings, and so on.
And does that not, and how do you reconcile that with the independent panel that comments?
Yes. No, thank you, Justice Lukolin. No, the independent panel, I won't belabor this point. You'll see it when you read the Act on your own. The independent panel is to be equated with the what is called the Justice Conduct Committee. Because that's why it's so uncanny how what is happening now with the public protector really should have just been, they should have used this model. Because here you also have the Justice Conduct Committee doing exactly, Justice Lukoleni, what you are saying, finding the prima facie existence of the case. I'll find the section, I think it's section, might be 16. Sorry. Yes, if you 16.4. 16.4, it's on page 12 of 25 of the ones that I've just handed up to you. So for the purposes of a meeting in subsection 2, that is of the committee may request for further information from the complainant or any other person, blah, blah, blah. Then at the meeting, the committee must consider whether the complaint, if established, will prima facie indicate incapacity, gross incompetence, and gross misconduct by the respondent, and refer it to the chairperson, and exactly the job of the independent panel. So So, and again, I'm glad you've asked that question, because there was some confusion in the committee itself when they were debating the merits of this matter against the sub judice rule. Because they seemed to think that this institutional predetermination is the independent panel, but clearly that is not. If you read paragraph 207, I think, of the EFF impeachment case, that's made very clear that it is about the existence of the ground, the establishment of the ground, not some prima facie step up. And that's, as we all know, how it works with the churches as well. Nobody has ever been or can actually be suspended just because there's a prima facie establishment. So that's something for the ages, I suppose, when Parliament does what it has to do. As we sit here, all we require is for this court to accept that the removal committee, which was contemplated by the founders of the Constitution in 1996, is not the predetermination committee or veracity committee that is happening now. And for that proposition, you don't have to go far. You just have to go to, and you don't even have to, I was saying to my colleagues, it's fascinating how my colleagues have been saying, yes, this committee is the removal committee. But its chairperson has been at pains to say, no, it's not the removal committee. But you don't even have to worry about that. All you have to worry about is the fact that it's clear, it's common sense, that until such time that there's a finding one way or the other, the impeachment or removal is not yet on the cards. So it seems very. I'm sorry, Justice Francis.
So, if I understand you correctly, assuming you're right, that there's actually two committees involved. The committee, the 194 committee, that's presently conducting impeachment proceedings.
1941.
Sorry,
yes.
941. That can continue. The only effect that your argument would have in relation to the suspension, because then the president would have jumped the gun.
Yes.
Is that?
No, absolutely. As far, if you, well, not quite, because as you know, later we say that there's the domino effect. But you're quite right, Justice Francis. If you look at it strictly from two perspectives. One, from the perspective of the ultra-virus point. Actually, only from that point. Then you're 100% right. In other words, if it's ultra-virus for this reason, then again, as I say, what will happen in the amendment process is whatever, is not our business. All I need to convince this court is that the point that was identified in 194.3a has not happened. That's all. And if we know that it would happen when the removal committee would start, then it means this one, even if it can last for 20 years, until the point where there's a removal committee, the suspension point would not have occurred. So I don't have to convince this court about speculative things. It's only to say the cutoff point has not been reached, full stop. And you're quite right, the implication of that, Justice Francis, would simply to then say, then the president did not have the power to act. And if that was the only thing we're bringing to this court, we would go away and the other process would continue. But the only thing that would be nullified would be the suspension, 100%. Later, of course, and the point was made by Justice Nuku about what we call the domino effect, and I will explain that as well, because I think Mr. Breitenbach missed that point with respect to him. So that's that point, yeah. It's inescapable. It's pleaded. It's there. It's big, and it can be avoided. And it's the job of this court to interpret the Constitution contextually, to interpret the Constitution purposely, which I'll come to now, but to also interpret it in terms of Section 39(2) of the Constitution. So 194 must be interpreted in terms of 39.2. In other words, to give it, to give the human rights flavor. And we've made that point somewhere, I think in our heads, or in where we say that when interpreting any legislation and when developing the common law, customary law, every court or tribunal or forum must promote the spirit, purport, and objects of the Bill of Rights. It's generally accepted that that interpretation tool is used for, let's call it, the non-Bill of Rights parts of the Constitution. Now, the other thing, before I go to the Hande case, is also to address a point raised to me by Justice Francis yesterday, which is, well, what about protecting the institution? Fair point, and I gave an answer yesterday. But the point, the only point I wish to make now is simply to say that and it goes to this issue I was talking about divination. You know, everyone just picks up a particular value of the Constitution just because they want to interpret a particular outcome, so to speak. But you cannot do that. The values of the Constitution must be looked at, all of them. So you must look at dignity, just as you must look at accountability. Nobody is saying you mustn't look at accountability. You must look at accountability, but you can't promote accountability into, some heights, undeserved heights. That value of accountability must be measured against the other values. Ubuntu is a value. Human dignity is a value. Transparency is a value. The rule of law is a value. Openness is a value. Supremacy of the Constitution is a value. So to elevate one value just to achieve a particular result is what Justice Kendridge called not interpretation but divination. So the purpose, and so by the way, is the independence of the public protector. That's a value. It's a constitutional value which must be guarded jealously. And that value is, as I made the point, I want to remake the point, was reaffirmed by our Constitutional Court in the certification case. But if you don't believe me, then you go to Section 194, and you'll see that the protective value or the protective quality in Section 194 is well captured. And by the way, in the EFF Gaza judgment, again, Mkhwebane CJ for the unanimous court goes on about why the public protector must be protected. Constitutional protection, that value of the protection of the independence. And I just wanted to refer, Justice Francis, apropos that little debate or discussion we had, to what then was the outcome of the certification case. And that outcome is to be found at Section 194 A and B, I suppose. Because as a result of that protective intention to protect the public protector and the Auditor General in particular, this was the outcome. It says the resolution of the National Assembly concerning the removal from office of the public protector or the Auditor General must be adopted by a supportive vote of at least 2/3 of the members of the Assembly, or a member of a commission must be adopted with a supporting vote of a majority of the members. What this means is that for all the other heads of Chapter 9 institutions, a simple majority of 50 will be sufficient. But for those that must be particularly protected, it must be 2/3, just as judges. So that's a value. It's not a value that we can poo-poo and say, no, it doesn't matter. She must not be protected. Why? Because, we want accountability. We want it now, even if it's illegal. How can you have accountability by an illegal process? That's not accountability. it's like this thing that gets bandied about Section 237. No, these things must be done diligently and what have you. But that presupposes that what you are doing is legal. Because if you are going to do an illegal thing diligently, that's actually wrong. So you can't hide behind Section 237. In fact, it's worse to do something illegal diligently. You should rather do it slowly. So, and this is the danger about elevating a particular value and not looking at the big picture. The Constitution is a framework. It is not a, you can't just pick one sentence and then want to hone into it. You have to look at it. When you look at 194.3, as I said yesterday, you can't do that without looking at Chapter 2 of the Constitution. You can't do that without looking at the dignity. You can't do that, in particular on these facts, without looking at Section 7.2 of the Constitution, my lords, which really is the operative section that says that imposes duties on these respondents. It says the state, and the state is the president and these respondents. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. So that's the context. The Constitution is not something that you just apply to suit your needs. You have to look at it, and when you say purposely, that's exactly what we mean. It must fulfill its purpose. Now, we are told that Mr. Badlander, I think that's fine. Just a quick one on the. You'll forgive me, my lords, because I'm trying to save time, so I might be moving.
Perhaps I should just remind you, the Rule 7 issue, I said you're going to deal with it in.
Oh yes, in the plan. Okay, let me. No, okay, that one is quick. Right. No, the Rule 7 issue goes like this. Well, fortunately, we now know that there's no Rule 41 application. The Rule 7 issue is very sad, because as you pointed out, Justice Nugu, why would state parties, independent arms of government, the National Assembly, Ms. Dosiviwe Mapisa Ngakula and Mr. Janchi, want the public protector, or even have anything to do with whether the public protector is represented by Sianeho attorneys or any other attorneys? The reason is not about Sianeho attorneys. This is part of the humiliation of the public protector. She must be stripped naked, she must be lynched in front of the mob, and she must be unprotected. That's all. It's got nothing to do with Sianeho attorneys. And by everyone, I mean, it's not enough that she's lynched daily by the DA from the day that she took office and called a spy and all sorts of things. But she must be isolated. In the lingo, we call it the pull her down syndrome. And sometimes it manifests itself as it has here as black on black violence. So she has to be really taught a lesson. Because, my lords, if this was a matter, as Mr. Breitenbach wants us to believe, that we're worried about public funds and what have you, then two questions must be asked. The people who sent my learned friend here to sit here, on the guise of saving funds, but they are spending money on an advocate to sit here for 2 days for nothing. When there's no application, a certain for Rule 41 application. But also, look at it now from a constitutionalist point of view. Let's assume for a minute, justices, that there's something wrong with this whole thing of the Sianeho or whatnot. Or let's say there's something wrong with what the acting public protector is doing in this interference. Maybe the new attorneys, it's against the PFMA or what have you. It's just a waste of our money. Then who's going to hold her to account? Who's going to hold her to account? Because the parliament that's supposed to hold her to account is here telling you that she's fine. We should not have attorneys. It's just wrong at the most basic level. And Mr. Janji comes to this court to say the public protector must not have attorneys. And tomorrow he's going to be sitting as a neutral chair, checking the veracity of the claims. And the whole thing is just a fuss. And so you are told that in terms of Rule 7, she must produce a power of attorney signed by Advocate Galega. What is that? The law is very clear. It says the acting public protector will assume, and you pointed this out, Justice Nugu, the functions of the public protector. Now, even this public protector does not have the function of appointing attorneys. That is the function of the CEO in terms of the PFMA. So how can you, by assuming her functions, assume functions that she herself does not have? That is why the letter you were referred to by Mr. Breitenbach is written in very specific terms. It says, "Dear Mr. Sianeho, first paragraph, we hereby appoint you to act for the public protector in the matter against the speaker." And then it goes on. Paragraph 5, it then says, "Please remember that when you submit your accounts to the Office of the Public Protector, or PPSA, I think, which is the juristic person. It's very clear. Signed, the CEO. It's got nothing to do with Advocate Mkhwebane. But now we must be told that no, Advocate Galega, as part of this lynch mob, is to assume some functions that she herself doesn't have. No, we cannot allow these people to do this. It's just wrong. Because firstly, it has nothing to do with them. It has been handled by the people to whom it matters. And in any event, this letter that I'm talking about closes the matter down. Because as we know, the law in Rule 7 now says that as long as the attorney, once the authority is questioned, produces sufficient proof. It's no longer, it used to be a power of attorney before, I think, 1992. But it's, as long as there's enough proof in front of the court that that person was appointed, that's it. That's the end of it. And I think one of the judges, I think it was Justice Lekuluni, asked the pertinent question. Yes, okay, now we see that this person was appointed in respect of this matter, or historically speaking, because we know it's been one continuum matter. When were they fired? When was that mandate withdrawn? Dololo.
So, if I understand you correctly, then the letter that's been produced as proof of authority to act, that letter covers these proceedings as well.
Absolutely.
Yeah.
Yes, it does. Because it's common cause, Justice Francis, that everybody knows that these matters, Mr. Padland has been telling you about 21 judges. I'll come to that. But in doing so, he was telling you that this is one continuum of a matter. And he's right, because each matter has been, even as we sit now, there's, as he correctly pointed out, there's a rescission application of the Bartman J judgment, which was a sequel to the Saldanha J judgment. So they're all, so that mandate has never expired, or let's put it the other way around. Those who are questioning that mandate are the ones who should be saying to the court, here's the letter, as Justice Lekuleni said, which terminated this matter. Yes, we see this letter here, we know it. It's too old. On such and such a date, there was another letter that said, you are fired. That has never happened. We just got some notice of withdrawal from people that we don't know. So really the Rule 7 matter should just be taken to the dustbin where it belongs. And it's just a nuisance, really. That's the only value that it has brought to this matter, to this matter. And it came in various guises. The so-called Rule 41 attempt was part of that same system, but it also collapsed. So that application must be dismissed. And I'll talk about costs later. But let's talk about the 21 judges. That's a myth. There are no 21 judges who have just drama for no reason. What has actually happened in real life is the following: that the public protector, literally, since the DA wanted to impeach her from day one, and I mean that literally, from the day she was appointed up to now, has at every step shown that the DA is just being malicious and vindictive and rushing things and doing things, and here we are. That's why we have 21 judges, so-called. She said they started this in 2017, my lords, or so. She was appointed only in 2016. But this one of the litigation, as soon as there was, I think, the very first case, because this whole thing is supposedly based on judgment, then they said, let's impeach her. She wrote a letter. It's in the papers in the Saldanha J matter. Long letter. I don't know who wrote it. It wasn't me. But and the essence of the letter was, you can't impeach me when there are no rules. It's all very well that Mr. Steenhuisen is jumping up and down, but you can't impeach me when there are no rules. She was proven right. They then realized, oh, okay, she's right. And went on and, as I say, plagiarized the Rule 89 rules, and except for changing here and there, and forgot to put the removal committee in the process. And then she on the 3rd of December 2019, eventually the rules were passed. 72 hours later, the first Mazone motion from the DA came on the 6th of December 2019. Again, a shoddy job which had to be withdrawn, and then they had to put, because when we pointed out in a letter on the 31st of March 2020, that you cannot charge her for retrospectively to the time when the Justice will remember this point, from before the actual adoption of the rules. Then they found some person who's going to testify tomorrow, incidentally, to put a complaint that she had invited certain people at her 50th birthday party or something, just to beat the retrospectivity point. And then in February, they put the new motion, the current one that we have now. Then that went on. Then we had the Saldanha J case. Then we had the Bartman J case, where she succeeded in showing that even the rules that they had put after all those years were unconstitutional in two important respects. And sort of to digress, at that point, something remarkable happened, which I know this case in and out, but there's one thing that still beats me until today. And it is that the DA, after the Bartman case, decided not to appeal against where we were successful on the issue of the legal representation. They only appealed the other issue. In other words, they were accepting that the rules were unconstitutional themselves, the drafters of the rules. But the Speaker of Parliament, of all people, supposed to be neutral, appealed against the public protector so that she must not have a legal representation in the inquiry. That's why this so-called Rule 7 thing, it's a continuation of that vendetta that she must never have lawyers to assist her. Or at least not lawyers of her choice, especially Africans. But the point is that after the second case, as I say, she was vindicated. And it's no use, this thing of bean counting. Every day we hear this. No, there were 12 grounds that were raised and only 1 in 2. It doesn't work like that. This is not a kindergarten. We succeeded in getting the most important relief we sought, which was to secure the legal representation of the public protector, without which she would be lynched as we speak now. But she's not going to be lynched because this court found that she's entitled to legal representation. And we succeeded in the other one. We may yet succeed. It's the one that's pending in the rescission proceedings about the involvement of judges in the independent panel, which it is common cause will bring the whole process back to
You may proceed,
Yes.
Mr. Mkhwebane. I was just conferring with my brothers about the time
Yeah.
that we can give you the leeway for. We'll sit until quarter to 5.
Quarter to 5.
The latest that we can see. So you can make your submission to Platinum.
I'll make a submission at quarter to 5.
Well, you're just about to wrap up. I'm not inviting you.
No, thanks. I understand. Thank you, my lord. Yes. Now the point I'm simply making is that she succeeded, and then up to now, up to today, literally, as I say, the results of her continuous success has been the fact that tomorrow I will be sitting representing her at the inquiry. So this thing about 10 grounds and what is just a made-up story. But anyway, I suppose if it makes other people happy, that's fine. So the other point which I just want to make very quickly about Section 96, but I think the point was made, but just to explain it in context, is that Section 96 is a measure which portrays exactly why the question that was put about trying to equate an executive member and a member of the judiciary just cannot wash. It cannot wash because the Constitution, if the constitutional drafters wanted to equate those two offices, they would have put an equivalent of Section 96 for judges. But Section 96 specifically says members of the executive, of the cabinet, and so on. So it's custom designed for them. Yes, it is true that when it comes to the common law sections or Nemo Judex, everyone, whether you are a judge or an official at Home Affairs or whatever, you may not act where you have a particular interest. Happens every day. People sit in board meetings and declare their interest, or sit outside in a meeting It's that applies to everyone. But this one has been custom made for members of the executive, exactly because they are powerful and they have, as we know, a penchant for doing certain things, or at least they might use that power wrongly. So it's again a protective measure, not for them, it's to protect the society, the victims, as always. So if you don't like Section 96 too, then don't be a member of the cabinet. It's very simple. Then you'll be treated like all of us. Yes, the handy point I wanted to make, it goes back to the interpretation point. We know that, and one of my learned friends made the point validly, that what we're not doing is, we're not saying we are attacking the constitutionality of the rules because they don't provide for a removal committee. Someone else will do that. We are saying that in even interpreting the Constitution and even the rules, that must be done for them to be in conformity with the Constitution. That's a different thing. And that subtle difference is set out in the Hande case, which is Hande, which to those of us who are not schooled, we call it Hyundai. But I'm told it's Hande. Hande is serious economic offenses and others versus Hande motor distributors, in Re, Hande, and others. It's 2000 bracket 10 BCLR 1079. And that case, in a nutshell, makes the point that if you, it was Langer DP, that when you do an interpretational exercise, it shouldn't be your first choice to jump for unconstitutionality. That you must do when all else has failed, and all else means trying to interpret that instrument, so in using 39.2 and so on, in the spirit of the Constitution. If even after that exercise it doesn't work, then you declare. Otherwise, we would be declaring unconstitutionality every day, which is undesirable for other policy reasons. Now, when did the proceedings start? We still don't know. We now have so many versions. My learned friend, Ms. Pillay, said it's 21st July, and I think she was making a mistake, a small mistake. She wanted to say 20th July, because 21st July was the date when the letter was written by the former speaker to the president to say that the first meeting was on the 20th. So I'm not taking that point. But the point I want to take is that that letter, the very letter that she relies on to fix that date, says that, dear Mr. President, I want to tell you that the committee sat yesterday and the proceedings will now start. In other words, will start in the future. This is on the 21st. So the date, that date cannot be the 20th of July, because it says will. The word will means it's going to start maybe tomorrow or whenever. So the earliest would be the 22nd of July. But it can be before that letter that says will start. So again, we're back into this fuzzy thing that says it must have started. We must do all this as what I call mental gymnastics to determine the date. What is the date? Nobody's answering. And Mr. Badlander, for his part, says no, it was the 16th of March. So there's a war there among the respondents. I don't know what Mr. Breitenbach says, but I know Mr. Janchi says it was the 22nd of February. He said it last week somewhere. So, I mean, the point is simply this. And again, one of the justices made the point. Oh, that's when I was saying Mr. Badlander's issue about the 17th of March helps us. I meant it in that context. Because it doesn't, he's quite right. The important date is the 17th of March. It's common cause from the president that from the 17th of March, he kick-started the suspension process. So the fact that it occurred on the 9th of June, if it wasn't for these other issues of Pala and so on, would be unremarkable. The most important thing is that it was kick-started on the 17th of March. So quite frankly, anything that happened after that date cannot be used ex post facto, and Justice Francis pointed this out, to say, no, on the 22nd of April there was a letter, an Audi letter, so then it must have started then. Any date that falls after the 17th of March means that the president acted ultra vires. Simple. Any date that falls after the 17th of March means the president acted ultra vires. So whether the thing is starting today or tomorrow or next year or yesterday or on the 18th of March, it doesn't matter. The fact is that when he kick-started the suspension process, he was acting ultra vires. Because even on their version, or at least one of their versions, the proceedings would have started on the 22nd of April or whatever. Quite apart from the issues, the outstanding issues which were not, the fact that there were no evidence leaders, I made that point yesterday, I don't want to belabor it. So all we have done now is, on top of all the issues that we had raised, we introduced the issue of the removal committee. But all the other grounds stayed. And until today, we've been here now in this matter 21 judges later. Nobody's still telling us when did the proceedings start. And that's the point I was making about the so-called 21 judges. Because at every step in that process, we have been successful and vindicated. And long may it continue. Now, please allow me to make this point, Justice Mkhwebane, and I'll make it very quickly, because I should have made it earlier when I was talking about Busisiwe. The other crucial thing about the CR17 matter is that that matter is not only about this thing about continuing litigation and so on. That matter is one of the charges in the impeachment process. I mean, if that is not a conflict, nothing ever will be. My learned friend, Ms. Pillay, tells you suspension letter. Okay, I don't have it right here, but the suspension letter, I think it's paragraph 7. Paragraph 7 of the suspension letter goes chapter and verse as to how the president says, he says, I'm suspending you. One of the reasons I'm suspending you is because I read the report of the independent panel. That's what he says in paragraph 7. That report of the independent panel says that one of the charges for which Advocate Mkhwebane must be impeached is the CR17 matter. You'll see that in the independent panel. Is it paragraph 7? Yes. It's 258, I think. 258 of volume 1. The letter.
Which bundle would that be?
Volume 1 of bundle B, I'm sorry, my lord. Yes, bundle B. Oh, thank you so much. Yes, it's 258. And yeah, that's what Sorry. Sorry, I'm misleading you. It's 261, I'm sorry. It says it's 7.3. I therefore had specific regard and considered the following conclusions of the panel to be highly relevant to the question of your suspension. Then it goes to town about incompetence, patently wrong, your findings were. Those findings were made in none other than, among others, the CR17 Busasa case. So the person who is a witness, a potential witness at least, because he made the allegations for which she must be impeached according to them, must sit and decide whether she must be suspended or not. Anyway, but that's the law according to my learned friends. And then I just want to address one thing, my lords, just so that we get it out of the way. The thing about the letter of the 10th. I heard Justice Noku saying that was a benign letter. It was not.
Yes, my reading of it is that the speaker was conveying what was conveyed to her by the members or the chairperson of that committee. She didn't suggest that the proceedings had started. My reading of it. I said it in that sense.
No, I understand, Justice Noku. No, that's why I'm glad you raised it, because it worried me, and I want to address it squarely. That's why we welcome questions from the bench, because it gives an opportunity to address the issues. No, that is not a benign letter. That is the most malevolent letter you've ever seen in your life, because that's exactly, as I said, why we're here. That letter, firstly, is unauthorized, as I demonstrated yesterday. There's no basis. You will see when you read the JSC Act, for example, just like in the rules, at various parts it says the JSC must then advise the president or must advise the National Assembly and so on. And that's for a purpose, so that you can't just wake up one day and write a letter. The Chief Justice can't just wake up and write a letter to the president and say, I just thought I must just tell you how things are going in the JSC. No. There are particular points at which these things must be done, and they are prescribed. But this letter just came out of the blue. And I will show you, Justice Nogu, that although you are 100% correct that it was, I think the word you put it yesterday was that it was factually, it was describing the factual situation.
Yes.
But that's exactly, that's not the question. I'm not disputing that. But I'm saying something doesn't become benign simply because it's giving the factual situation. So if I say, for example, if the police come here and they're looking for my learned friend, and I tell them, it's this one. I'm expressing a factual situation. It's factually correct, but my motive is that he must be arrested, or she must be arrested, or probably the Impimpi who sold him out here. So the mere fact that and you're quite correct, Justice, that she was saying, yes, the committee has that, but that was not the reason for that. Because when we talk about irrationality, we talk about conduct and its motives and so on. It is very clear, there is no doubt about it, that that letter was meant to instigate and prompt and trigger the suspension.
But
and the president,
sorry, if that is so, why don't you then take and issue the letter of the 21st of July 2021? Because it seems to me that it was just a continuation of that pattern. On the 21st of July, the president is told that the committee, I'm not sure exactly the words, so don't hold me to them, the committee will be starting.
Will start.
Yes. And then down the line, the president is told, because of the pending litigation, the committee has decided to halt the proceedings. And now, after reading the judgment, the committee has decided to continue with the proceedings.
There are three problems with that, Justice Nugu. One is that I'm not a fan of the letter of the 21st of July, but it didn't produce anything. In other words, there was no, the suspension that is before you in our respectful submission was triggered by the letter of the 10th. So, but two, the letter of the 21st, in any event, could not have prompted a suspension because it said it will start. It still didn't have a date. So that's why we don't know when the proceedings started, because we had one that says it will start, then we had another one that says no, they've just resumed. But who? You know.
But then even this one says that the committee has decided to resume.
Yes, but let me put it this way, Justice Snook. I don't want to belabor the point because of time. The motive of that letter is borne out by actually what we know, which is that 7 days later, the president then writes the letter. And what does he do? He attaches the letter of the 10th. In fact, on the papers, you'll see that he issued a statement or rather, Parliament issued a statement, a media statement on the 15th, I think, 5 days after the letter, to say, we've now told the president so that the whole world must know. That's how significant it was. And then 2 days later, he writes the letter, and he attaches the letter to say, and in fairness, the one thing about the president is that he says, when we say to him, no, why did you do it on the 17th? He says, because I got a letter from the speaker. So it can be clearer than that. He says, what must I do?
But I got the impression that Ms. Pillay said it was not only that, he was also told by Mr. Kornoff, the parliamentary...
Yes, exactly. That's the third thing that is wrong with this picture. Because why is Ms. Nosiviwe Mapisa-Nqakula taking the job of Mr. Kornoff? Is she now the new Kornoff? Because what happened is she exactly unsolicited, the president has got his parliamentary counselor, if he wanted to know what's what in parliament. This is exactly the irrationality of knowing that she takes it upon herself to still prompt him. So that letter, as far as conduct is concerned, and we accept that it's not a decision, quote unquote, in the legal sense. Obviously, it's a decision to write a letter, but as conduct, it must be impugned because it is, as they say, the native that caused all the trouble. That's the letter that sparked the whole, the whole 21 judges episode. Without it, we would have had much less than 21 judges. Okay, I don't think Ms. Pillay seriously wanted to. No, she in fairness to her, no, she did concede the private, because I was going to talk about the pala, the dollars versus the presidential protection unit, but she did concede that there was that connection. Now, here's the other, no, it's not important, but let me just say it in passing. We are told that Ms. Kaleka or Advocate Kaleka's credentials are irrelevant. You know, the fact that she's a deputy, you know, so what? But in the state of capture case, where Mr. Badlander and I were on the same side, we argued there, ironically, successfully, that one of the reasons why the report had to be released was the fact that Advocate Madonsela had said that the person who's succeeding her has less experience in these things, namely Advocate Mkhwebane. And the court found that that was a rational basis for her to want the matter to be released. The point I'm simply making is that you can't just say, well, people differ. They will make different decisions, such as accepting that someone is exceptionally busy when they're selling ancolas. So when someone else might not make the same decision, that's just in life. We all do. If you might prefer a particular teacher or a particular lecturer or a particular judge, even as we pointed out. So it's not because
that addresses the argument that Well, the work is going to continue.
Yes.
So you say there the work could have continued under the successor.
Yes.
But the court accepted the fact that in those circumstances,
Yes.
it had to be continued. by
Absolutely.
the-
That it was someone else. And we've made the point, for example, in our papers that Ms. Galega has never done investigations. And there's nobody who knows that better than the public protector. Because as you know, in the Act, it says that she can only, her job, her normal job when she's not acting, is she can only act. In fact, this has been criticized in academic writings. So that the Deputy Public Protector can only have those powers that are delegated to her by the Public Protector. And I remember reading this in an article, and it's quite true. It means literally, if nothing is delegated to her, she'll just sit there and do nothing. So nobody knows what she is good at or what she does more than the Public Protector, because her powers are directly linked to her. So I'm saying that point is even, if that court, what's good, source for the goose is source for the gander. If that point was very good and made Mr. Madeleine and I to win a case in 2017.
My Lord, before I misrepresented, I wasn't in the case, but perhaps more importantly, I am unaware of a finding to that effect, and perhaps my learned friend can actually point you to the judgment, because I'm unaware of a judgment saying that. But I wasn't. I've been my learned friend's junior many times, but it wasn't in that case. He won that one without me.
Well, you could have taken the credit because it's
I know, but I was taught you must be careful about taking credit for things you weren't involved in. It might end up coming back to bite you, and I'm worried about it in this case.
Yes, no, Mr. Badland is quite right, because his silence could have been used against him.
Well, he did say that he ironically was successful.
Yes, yes. Anyway, it's
maybe you can give us a note about
yes, I will. I think it's around about paragraph 78. Is that our plan? All right. It's there. We'll find it. And I'm not going back to that point. I was just simply saying that it's a twist of irony.
But can I just say, there is an important point. And so if my learned friend is going to rely on that authority, then he should, he can do it after the hearing. It doesn't have to be now. But he should do it, we should be entitled to look at it, because I'm unaware of that judgment saying that. If it is, I'm wrong, and it will be as my children tell me repeatedly, it happens all the time. So, but thank you.
No, that is true. Well, it's certainly happening this time. 286. All right.
Yes.
Okay, it's
I really have no difficulty with it being done after the hearing.
no, it's fine. Let's do it now. Get it out of the way. It's paragraph 164 of the judgment. President, it's our bundle B, list of authorities 329.
Thank you.
So the President refers to the typed transcript of the meeting that took place between himself and the Public Protector on 6 October 2016. He points out that during their discussion, the Public Protector, that's Advocate Matonsela, said the following about her successor, Advocate Mkhwebane. The Public Protector that you have appointed only operated as a senior investigator in the Public Protector's office. That is a level junior to her current position. So she herself will still have to acclimatize to this new position. The President advances the argument that it was irrational for the Public Protector to instruct him to establish a commission of inquiry, and so on. Then says, in our view, the Public Protector's concerns were entirely justified and rational. It was important that the matter be finalized as soon as possible, as there would inevitably have been a delay if she passed the matter to the new Public Protector, Advocate Mkhwebane, who would have to start from scratch, who would have to familiarize herself with a veritable mass of information and documentation. This would have seriously delayed the finalization of the investigation. And the point is simply that the one that Justice Nuku made, again, it's just common sense. You don't have to be a lawyer. That if someone was seized with an investigation and now someone else must take it over, then that person obviously has to familiarize themselves in a similar way, even if they were of similar experience, let alone when the other one was a deputy who has never dabbled in serious investigations such as that.
I must deal with this, but I'm happy to deal with it at the end, because we do not accept that reading of that paragraph, and we do not accept it as authority for the proposition that's been advanced. But I don't want to interrupt. I'll deal with it at the end if you prefer. It's a new submission made in argument, and I'm on a new authority, and I'm entitled to deal with it with respect. And
it's not a new authority. This authority has been here since the first 20 of the 21 judges. This is an authority we relied on from day one. This case of the Jacob Zuma conflict of interest. Even this, every time we've had this case. But if Mr. Badlander has never read the full judgment, I'll allow him to speak later. That's fine.
Are you close to wrapping up, Mr. Mpofu?
Yes, I am, my lord. I just wanted to.
Even exceeded our.
Yes, my lord. I was hoping
accommodation.
I was hoping the clock is not working. I've made the forum shopping point. The issue, the protection clause in the EFF Nkandla is paragraph 50. That's all I just want to say. It's in paragraph 50 where they talk about the need to protect the public protector. Here's an interesting one. Mr. Badlander always accuses us of peddling conspiracies. Here's an interesting point, which also might hopefully influence Justice Nuku to realize that letter was not as benign as it might look. If you remember, why are these people doing this? Why the first respondent, second respondent, third respondent, acting public protector, all attacking the in various forms for Advocate Mkhwebane, particularly in relation to the speaker. You must remember when we talk about one of the conflict points, which is the Zimbabwe trip. The Zimbabwe trip doesn't only help us, also it's another one that shows the private-public issue. Because you'll remember, in a nutshell, that it was the Minister of Defense took ANC comrades on a trip to Zimbabwe on an official plane, to paraphrase it. And that issue is one of the, as we call it, the issues that create this conflict. But few people remember who was the Minister of Defense at that time. It was none other than Mr. Siviwe Mapisa-Ngakula, who now happens to be the Speaker. And so what we're saying is that the warnings that were put in the EFF Nkandla case about investigating people, powerful people, might be coming home to roost, because whether she being the public protector was investigating the Zimbabwe trip against the president per se, but the truth is that, in fact, I think in one of the letters there, the president actually wrote a letter reprimanding the then minister for the trip, and I think that's where the matter is now. But that's something that should be remembered. But that none of these people are acting without any motives that were foreseen in the EFF Nkandla judgment. I'm cutting out Justice now. I don't think the Stalingrad thing deserves any response. Because I don't understand how someone who's actually undergoing, their whole case was that she's avoiding the inquiry. She's now attending the inquiry, but it's still Stalingrad. Right. Yes. No, I think the last submission, Justices, will be Mr. Badlander said that it doesn't. We've catalogued, and I've tried to do this as we go along, how clearly wrong the Part A judgment was, just in case the other arguments don't succeed. And we're saying A, it was clearly wrong. B, it's under appeal. C, it was on a different footing to what we're busy with here. And therefore, its value should be really discounted to the bare minimum. And we made the point, because I don't have time, the most dramatic point we made was the fact that that judgment, how clearly wrong it was, is shown by the fact that the very first words of the entire thing says the Public Protector of South Africa. But the judgment at paragraph 77 says the applicant is somebody else. So once you start there, it's difficult to recover into clearly right, as they put it. And also, just to say that according to the DA, we must be mulcted with costs, because punitive and personal costs, because among other things, we said the judgment was clearly wrong. And to make a statement like that from someone who also goes with the title of Advocate Mazzoni is very disturbing. It's not an insult to say a judgment is clearly wrong. It's what lawyers do. In the Patma judgment that my learned friend Ms. Pillay read, that's what happened.
It's what you must demonstrate.
Absolutely.
So that you can then...
You can escape the stare decisis. Yeah. Lawyers do that every day. So every lawyer knows that, except, as I say, Advocate Mazzoni. So the last point then is cost. The cost, we are quite serious, Justice Nogu, about asking for cost. I won't belabor the point. If you look at our Part A affidavits, it is disturbing, and I'm using that word advisedly, that officials, people acting in their official capacities, can get away with, I didn't even start to show you where there's just pure misrepresentation of facts, there's obfuscation, there's vendetta, there's political hyperbole, and all sorts of ways of trying to lynch and denude Advocate Mkhwebane of her rights. And our courts should not be more tolerant of other official actors doing this. But when it is her, she as it was done liberally by the Part A court, personal costs, for what? They said because she made ruinous allegations, unspecified. What are they? What did she say? You know, it's just a routine. And this I'm saying in all seriousness, because I argued this matter in the Constitutional Court successfully in the matter of Public Protector versus Commissioner for SARS. Yes, I think it's reported at 2022, volume 1, SA, page 370, CC. And you'll find towards the end, Badlanga J says the following, because I made these submissions, that it is, and that's why I was saying I'm using the word disturbing, that the courts, particularly the courts in Gauteng, were mulcting the public protector with disturbing frequency with personal cost orders. And it warned that it must not be fashionable for judges to mulct with costs, because that would undermine the office. I'm paraphrasing. I think it's around paragraph 43 or 44 of that judgment. And the judges of the Constitutional Court unanimously pointed out that there were 4 matters where she had been mulcted with costs, and they had only upheld the order in 1 of those 4 matters. And they issued this warning quite seriously. And that's a matter of and as far as I know, I've not read all the law books, but I don't think there's ever been a litigant where the courts, the highest court for that, says that this person is being targeted for particular treatment, to paraphrase what Justice Matlanga was saying. And she says it's a caution to the courts to do that. So I'm arguing probably that proposition in the converse, to say, just as there is readiness, let's put it like that, generously, readiness when it is perceived that she has done something around litigation, that should apply to all public officials, because after all, we're told that is done so that it can be an example to others. But all those others are allowed to get away with murder, such as in this case. Because we shouldn't be here. I mean, it can be that a president who has been told that there are 4 conflicts against you, a president who has admitted to that conflict in respect of other instances, a president who has just been given 31 questions, a president who knows that there's an imminent judgment that is coming to deal with his powers, a president who has agreed to wait until the outcome or rather to inform the public protector before making the suspension decision, all of a sudden forgets all those things. Why? Because he can get away with it. We must not let this happen, because it's going to be a precedent that we can't turn a blind eye to such abuse of our courts and abuse of the system, and more importantly, abuse of Advocate Mkhwebane. She herself is used to it, but it must be stopped in respect of other litigants, to protect other litigants. Let's go, please.
Thank you, Mr. Mkhwebane.
I'm so sorry. Oh yes. I'm so sorry. I have to. Just 1 minute. Again, it will be quick because Justice Francis pointed this out, but it's quite a big point, which is also related to the judgment that Mr. Badlender was talking about now, the state of capture judgment. And if I had time, I would say this. I once recommended somebody to go to the SCA in the JSC just because of this point. And I said it to her. I said, it's because she picked up in a judgment the difference between the and a, which many people like me who went to the Bantu education schools don't. Now, the point is this. In that case, the president of the ANC and the country had said, I'm going to appoint the commission. And I had argued there that if he was not referring to the same commission that Advocate Badonsela had been talking about, he would have said, I'm going to appoint a commission, not the commission. And that you'll find in this judgment, it's in the judgment of the court. The importance of that is this point that we made yesterday, but Justice Francis raised. It's being what is called honest and disciplined to the text of what you are interpreting. And it is this. When Section 194.3a says, the President may suspend a person from the office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. Two issues arise from there. The first one is that the words for the removal of a person are not there just for show. They indicate that we're talking about a removal committee, which this one is not. But the more important issue which I want to make is that if the writers of the Constitution were referring to the same committee as 194.1b, then they would not have said the proceedings of a committee. They would have said at any time after the start of the proceedings of the committee, in other words, the committee that we just spoke about now in 194.1b. Very, very important. So that puts it beyond doubt that the interpretation which you contend for, that the framers had another committee in mind here, a la JSC small committee, small JSC, is sustainable just on the linguistic treatment of those two sections. Thank you. Those are our submissions. Let's court, please. We're indebted to the court for the extended time and the staff. Thank you.
Justice Nuku, could I beg the court's indulgence to just deal with this one point? Before I do so, I owe my learned friend an apology. I was in the case. There have been so many public protector cases that I got confused. I was for the DA, he was for the EFF. We both won, but I'm sure it was all his doing.
Sorry, now he owes me an apology. I was for the UDM and COPE. I don't know anything about the EFF.
I'm sure he won the case, and I was happy in his coattails. But, so I was wrong on that. But with respect, on the effect of the judgment, I was right. When you read, and the court will do it in its own time, what is said, it's at page 330 of the applicant's bundle of authorities, paragraph 166, but just in case there's any doubt, the reference is 2018, volume 2, essay 100, and it's at paragraph 166. That was a case. That was the state of capture case, where Advocate Madonsela had said, I direct the President to appoint a commission because I'm not done with my investigation. And the President had come to court and said, no, you didn't need a commission. You could have just let Advocate Mkhwebane take over. And the public protector said, those defending her report said, no, Advocate Mkhwebane is inexperienced, etc., etc. And what the court held, never mind what anyone argued, what the court held was, in our view, the public protector's concerns were justified and rational. It was important that the matter be delayed, be finalized as soon as possible, and there would have inevitably been a delay if she passed the matter on to the new public protector. Advocate Mkhwebane would have had to start from scratch. She would have had to familiarize herself with the massive documentation and information. This would have seriously delayed the finalization of the investigation. Now, in this case, on Pala Pala first went to this public protector on the 3rd of June, and she was suspended on the 9th of June. So the delay point, if there was a delay, it would have taken 6 days. Unless she knew about it in advance, which I'm sure she didn't, she only had it for 6 days. So if instead of suspending, if the suspension could have caused at most a delay of 6 days. And of course we know in the meantime she was waiting for the President to answer. So there could have been no delay. So this authority is no authority at all for that proposition, and you've had no authority or argument as to why there would be benefit to the President in having it decided by the Deputy Public Protector instead of the Public Protector. You've had no argument on that. No facts, no argument. And so we persist in the submission, and I say with great respect that this case doesn't avoid the problem. Those are my submissions. I'm indebted for the indulgence. Thank you, my learned friend.
Thank you, Mr. Daslender.
I have nothing to say.
Ms. Mkhwebane, you wanted.
Yes, my lord. I'm terribly sorry for burdening you with such last matter, but I do think appropriate to address just one thing on the Rule 7 that my colleague, Mr. Mpofu, raised.
Well, your difficulty is that you have no litigant, you have no party that you are representing that is before court.
Understood.
The issue by Rule 7 was raised by one of the litigants. It was argued.
Understood, my lord. But remember when the Rule 7 came up, when Advocate Mpofu and I had that debate about the withdrawal notice, Advocate Breitenbach then made the suggestion that because his Rule 7 is on the papers, that we proceed on that basis, and the court then requested my input on that particular subject. I said it was a sensible proposal because it was never the intention of the Public Protector's Office to stop the proceedings. So if I persisted with the withdrawal, this proceedings would have not proceeded. So it was never the intention, and Mr. Mpofu, Sianeho attorneys, was informed right from the beginning that the Public Protector's position was, remove us, but you go ahead and we're happy to fund you. So when that proposal came for the Rule 7 to be addressed in that way, we welcomed it because we didn't want to stop the proceedings. But it is not because, that being said, my lords, some things were said by Mr. Mpofu then when he now addressed the Rule 7 thing, which I think the Rule 7 application, which, and there are some aspects which you mentioned, which I think is incorrect, and the record correctly reflects the authority of the current attorneys and the current position of the Public Protector's Office, which, as I said, was not to stop the proceedings. Mr. Mpofu referred the court to a letter that said that he had authority, that Sianeho attorneys had authorities, and that particular letter confirms it. But that letter is dated December 2019, and that was signed by the previous CEO then, that confirmed his Sianeho's attorney's instructions to proceed. There's another letter on the record, and this is also part of the reason why we thought, since everything is on record, let's not proceed with the withdrawal, because the court would be well aggrieved of what the Public Protector's position is. In the letter 4 July, which was addressed to Sianeho attorneys, which I believe is on in the record on page 603 of Bundle B, Sianeho attorneys was then informed again by the Public Protector's Office, and not just the Public Protector's Office or the Public Protector, but the current CEO wrote to Sianeho attorneys and told them, this is our position. You proceed, give us budget estimates, and we're happy to fund you to proceed, but we don't want to participate. Advocate Mkhwebane must proceed in her personal capacity. Sianeho attorneys responded and said, well, we do not agree with how you view Advocate Mkhwebane versus the Office of the Public Protector. We will, in any event, address your concerns and join her through the proceedings. And that is also on record in that letter dated 4 July, which is on page 603 of the record. So, what then happened after that letter was received, the Public Protector responded and wrote to the registrar of this court and informed them that that Sianeho attorneys do not have authority to act on behalf of the Public Protector's Office. We do not wish to proceed with the matter. A withdrawal was sent that the Public Protector's Office should not participate. Nothing happened when the withdrawal notice was filed. Now, normally, or in the event, under these circumstances, one would have expected that Sianeho attorneys would have then raised the Rule 7 themselves and said, but we are on board, we have this letter, you do not have authority to represent.
But you see, the difficulty is that we are all arguing this in the air. We don't have any papers. There's a Rule 7 which was filed properly, and the manner in which the matter has been dealt with is very unsatisfactory, because if we must decide the matter, we must decide it on the papers.
Understood, my lord. It is on the papers, and like I said, the Public Protector did not want to withdraw this.
If there is something that you want to bring to our attention which is on the papers, you are welcome to do that. But beyond that, it's not going to help us.
It is on the papers. All the correspondence that I referred to now, I mean, it's part of the record. There's no application, I understand, for withdrawal, and the reason why we didn't proceed with that was because of the proposal that was made. We didn't.
And that ship has sailed. So now what we must deal with is the Rule 7 issue.
I just thought it well to bring it to the court's attention, the circumstances under which we did not proceed with the rules, with the withdrawal application, and clarify that that letter which.
Well, it was on the understanding that the Rule 7 issue will dispose of that issue. I don't think that you need to explain anything beyond that, because it was placed on record and it was canvassed with counsel involved, and so we'll proceed on that basis. So it's just going to turn on whether a case will be made out for Rule 7 and it's decided. I don't think that you need to respond.
No, I don't. I will, and I won't, because I don't know which application my learned friend is using. I just wanted to say one small thing to just take advantage. I want to belabor the point. There's a point about the domino effect, because I don't want to be understood to be saying that the suspension issue and the continuation of the inquiry are separate in response to Justice Francis. But in the Part A heads, you will see there's a point where we explain the way, if you start with the suspension, the dominoes will fall this way, and we say if you start with the interpretation, the dominoes will fall that way. I'll refer the court just to that, because I can't develop the point now, but I simply wanted to make our case is very strongly that the inquiry and all the meetings that took place, which culminated in the current inquiry, were all done on the incorrect premise that the proceedings had started, but also there's the fairness point which ties it with the what you call the Nemo Udex 129 AD2 says that process must be run according to fairness, including Nemo Udex, and it can't run according to fairness if there's a suspension. But that point is made in our party heads. I just wanted to highlight that. Thank you.
All right. On behalf of the bench, I would like to thank all counsel involved in the matter for the manner in which you have cooperated. At some point, it was doubtful that we were going to be able to finish the matter in 2 days, but thankfully we have. And on that note, judgment is reserved.
Thank you.
I'm going home.
Yeah. Okay, please. Can we make a pact, Stephen? Let's make a pact. No agents, and whoever loses is not going to appear.
Careful, put it